Good morning, everyone, and welcome to our national conference on the theme here at NALSAR University of Law. Our hope in conducting this event is to encourage entrepreneurs in the field of intellectual property law by facilitating knowledge sharing, introducing new angles from which to approach the subject, and to build on the experience of those who are already leading successful figures in the field. We would like to begin this morning by calling on Professor Ananda Sharar to address the attendees and begin the day's proceedings. Dr. Sarkar has a unique distinction of holding two PhDs, one in science and the other in law. He got his doctorate in intellectual property law from NALSAR in 2007, after which he pursued another one in industrial microbiology. Dr. Sarkar had a long stint in heading the intellectual property department at Biocon Group, which he was also instrumental in setting up. Additionally, he is visiting faculty on intellectual property to several universities and law schools. As of now, he is the DPIIT IPR chair, professor at NALSA University of Law, and is engaged in consulting, strategizing, teaching, and training programs in the field of IP management. So, if you would come to the podium.
Good morning, very good morning to all of you. I welcome all of you for today's event. I welcome our special guest, Madam Ananda Sharar, who is not someone who needs any introduction in the startup ecosystem. It is under her leadership that the IKP Knowledge Park has really blossomed to a fantastic incubation center. Welcome, Madam. I also welcome our dear Registrar, Professor K. Vidulata Reddy, to spare her time and join us this morning. A strong welcome to all participants, my colleagues and students. A special welcome to the participants from the African subcontinent, coming from 11 different countries, who have transformed this national conference into an international. So welcome to all of you. Now to say a few sentences about the startup ecosystem. The Indian startup ecosystem has really evolved, being the third largest after US and China. But if you really look into it, the starting of startups happened in the early 1980s when 7 engineers pulled up $250 and started an ICT company, which is today's tech giant Infosys, which is an inspiration for all of us. And today the industry employs close to 4.8 million people and should be close to 20 billion in the next 2 years. There are several startups. If you look by the government registration in India, it's crossed about 100,000 as per government registrations last year. And the good part is most of them are in tier 2 and tier 3 cities. If you really want to know, they're spread over 700 districts in the country. So we feel that this program, this event is aptly timed, and it will help us to become better and better and foster in our areas of the startup ecosystem. So welcome all, enjoy the event, enjoy the beautiful campus, make new friends, network, and have a wonderful day. Thank you.
Thank you, sir, for welcoming all of us here. Now, I would like to call upon our beloved registrar, Professor Vidulata Reddy, for addressing us and giving us a few words of encouragement.
So, good morning, all of you. And I welcome you all for coming for this one-day conference on intellectual property for startup businesses. A startup business, to my mind, the first thing that comes to me is what is the percentage of success in startup, even if we take worldwide or within India, the percentage of success in startup is still in single digit. If we say it is in the lower side of that also. So whom should we congratulate? I think we should congratulate the resilient families who have really allowed the people to do what they want and strive to evolve and try to be an entrepreneur, and even to emerge as a startup entrepreneur. I feel that the country like India and an economy like India and the families within India allowing their family members to do this kind of thing and to be able to give that kind of support is something which should not be undermined. Because when we talk of startup ecosystem, we are only talking of how much of the incubation centers are able to be, how many incubation centers are there within each state, what kind of support state is giving, like T Hub, where you have all kind of hand holding, where you have all kind of venture capitalists or mentors available for all of these kind of strategy building, uh, all mentoring from seed stage to till the stage that it takes off. So these kind of things, of course, we are loudly proclaiming. When we talk of startup ecosystem, we talk of technological partners, we talk of tie-ups with firms, we talk of educating them intellectual property, we talk of educating them in how to approach incubation and how to prepare a program project report to be able to present before the venture capitalists. All of this we are doing, and we are proudly claiming like our pre-pack regime for MSMEs. Like even if an MSME fail, how the government of India comes forth to support all of this. This is very highly we are being projecting, and of course all these add to the startup ecosystem, no doubt about that. But to me, as a, not as a person within the business industry, and as an academician and as an educator, if I look at it, I feel, because for us always we look at the students, when we look at the families who bring the students to our campus, and the parents are always thinking about placement and the future of their kid, the families which are allowing them to venture into this kind of thing, I think is the requirement for the nation today. Because most of the management schools, I would say, have stopped to be a management school and are not trying to work like a B school. Many of the, excepting few IMs and few management schools, many of them are only management schools, and they are not evolving like the proper B school model. There is a need that we need to have a twining of both the things, like business entrepreneurship and management education go hand in hand, and all our management departments stop thinking as management department and work towards evolving that kind of culture in the Indian students, where we take this from third stage, or where we are to the number one stage where we should arrive to. Maybe that's a dream that India is looking at. But when we look at making our Indian startup ecosystem more strong, when we talk about creating a strong, uh, developing startup ecosystem to that level where we are second to none, and also make sure not just we are starting the number of startups, but the serious thing that we need to look at is how do we enhance the success rate of the startups. Here comes the training, the importance of all kind of mentoring, the role of incubation centers come in here, the role of IP educators, everything comes here to enhance the rate of success rate within the startups. That's when we see India as more better off. And also it is a kind of true reward to the resilient families which were really taking the hardship. Because when the startup really succeeds, definitely government and the country is going to uh, gain a lot in terms of employment, in terms of tax revenue or whatnot you may call it. But when it is losing, it is the family which is taking the backstage. And look at, I have looked at the reason why I had to speak aloud here today, that is, I have seen families where when the child really failed after setting up the startup, the kind of trauma the family had to go through, the spouse support, that all of these things have really mattered. As a lawyer, I have also seen one or two divorce cases where the person left his job, tried out a startup, the wife not happy. Those kind of things also are many stories like that go on. And I don't think this is the stage we discuss that, but when we talk of startup ecosystem, we are somewhere missing out on the sociological or anthropological aspect of it. Rather, we are looking at it as only a business model and a business ecosystem and a patent, venture capital, financial, labor, organization, and all these things, but not from the other very important angle as well. However, today we have started, and one thing that I would like to definitely tell you is post-COVID, organizing conferences has become such a tough job, because people have got started used to that luxury of working from home or webinars and so on. But definitely nothing can match physical conference. So having this conference here, meeting the people, looking out, talking to each other is the kind of the other peer learning which happens in a physical conference, which was missing out for a long time. And I would definitely congratulate Ananda Sarkar and his team for taking this conference and organizing this in these days, and making you all, welcomed here. And I hope you will definitely have a good time. And I have to be especially thankful to our speakers, and more especially Madam Deepanvita Chattopadhyay, for taking out her time and coming all over here for doing this kind of to deliver the keynote address. And I wish that you all will enjoy this day, which should be very intellectually stimulating. And thank you and welcome to you all to the NALSAR campus.
Thank you, ma'am, for your kind words and endorsement of this event. And as we can see, the interesting perspectives have started right off the bat. I would next like to introduce our keynote speaker, Dr. Dipanvita Chattopadhyay. She is the chairman and CEO of IKP Knowledge Park and has developed the first like science research park in India right here in our city of Hyderabad. Apart from pioneering a hardware project incubator and market space, IKP Eden in Bangalore, she has worked with Indian and global partners to support over 1,400 innovation projects and early startups. She is the recipient of the Golden Jubilee Biotech Park Lifetime Achievement Award, the Vocational Excellence Award from the Rotary Club Hyderabad, and has been recognized as one of the top 10 enablers and champions of the incubation ecosystem in India by the Department of Science and Technology. She is also the recipient of the FICCI Flow Influential Women Award for outstanding contribution to the innovation ecosystem, and has been dubbed Top Women Achiever of the Year 2017 by Asia One Business Magazine and Women of the Decade in Life Sciences and Innovation by the Women Economic Forum. She has also authored the India chapter for the Global Innovative Index Report GII 2020. Having taken over as the chair of IKP in November of 2015, she is a director on the boards of IKP, IKP Trust, IKP Ventures, Research and Innovation Circle of Hyderabad, AIC CCMB, and the president of IKP Eden. She has also co-founded and chaired a startup, Support Elders Private Limited. With that introduction, ma'am, I would like to invite you to the podium.
Thank you. That was a long introduction for a 15-minute talk, but thank you so much, Dr. Sarkar, for inviting me. I call him Anindya, the first name. So very grateful to be in your campus. You know what? This is, though I know NALSAR from when it started, this is the first time I'm coming to your campus. Thank you for that. So I just, today's seminar is, today's conference is on a very special topic, IP for startup business. So I would request all startups here to raise their hands so that I know who we are talking to. 1, 2, 3, 4. Okay. I'm sure a few more startups will come because I know people from Bangalore will be coming, like Biomoneta. But I have to, then I think this group today is more of those who would support startups in their IP business. And that is also an extremely important job. If you don't understand the business of startups, you will not be able to guide them in terms of why IP or whether IP is strategic to startup businesses. We started our incubation center in our science park, IKP Knowledge Park, in 2006. Our first incubating company, Laurus Laboratories, has filed over 200 patents, and it is no longer a startup. India defines startup for only 20 years, and there is a cap on their revenues and so on. But Laurus is now a large integrated pharmaceutical company. How do you grow a startup from the early days to a matured company? Its IPO happened in 2016, December. The valuation of, I think, 4,500 crores is something that we really need to understand. If we have to talk of the early life cycle of startups, the first 5 years, 7 years, that's a very different phase than when we go for longer periods. And of course, I'm not generalizing startups. This is for pharmaceutical, chemistry, biotech kind of startups that have longer runway to be successful in terms of earning revenues or licensing technologies and so on and so forth. There are areas where you can do it much faster in the technology. So to all things that we are talking of are technology in terms of science and technology, but the way technology is defined, those areas, it could be IoT, it could be AI, it could be even ITES or e-commerce and so on. Their converting and commercialization periods are shorter. So the question is, and this is kind of it's open question to all of you, this is a global, and I took the data from unicorns. Unicorns, as you know, who have valuation of $1 billion and above. How many of unicorns have a patent portfolio? Any guess what would that number in terms of percentage? I don't see a hand going up. No wild guesses. 45%. Only 45% of unicorns globally actually focus on patents. One reason, of course, is that e-commerce and such platforms, which are software driven in several jurisdictions, including in India, have very high limitations on filing patents. And those numbers in India, as you know, are high in terms of unicorns. But all said and done, not all unicorns depend on their patent portfolio as a strategy for growing businesses. All of you may have heard of SpaceX. What is their strategy? Anybody? Do SpaceX actually focus on a lot of IP? Trade secret. Yes. Actually, SpaceX believes that trade secret is a much better option to go for than filing patents. One question I always have, and this is for all the faculty and including Dr. Sarkar, do patents or are patents a way of teaching inventions? So as you file patents, are you actually teaching people inventions? And is it helping them to build competitors a portfolio? So since we are here today with a lot of people, budding and experienced, who would be driving the IP strategy of startups, my question is, how do you actually frame those patents? How do you frame the IP strategy for startups? Because if that becomes a way of helping people understand the portfolio and competitors would love to see how patents are published, how it is written. What is the way to make it? How do you protect? How do you make yourself much more in terms of your business? How do you protect your business from your competitors? The question, of course, is if you are looking at growing your startups, you're growing your business in a non-linear fashion, what would the strategy be? Would the strategy be developing your own intellectual property over a period of time? You have to remember technology obsolescence is a big thing. And also in any discipline where IP is important, there are large players with deep pockets and ability to innovate faster. You may be agile as a startup. You may be able to really come up with new things. But globally, it has been seen that companies that scale quickly actually acquire IP. That is a strategy to be able to grow. I was looking at a data point of Twitter. Twitter, to most of us, is not a startup. But in the US, it is still treated as a startup. And when they had their IPO, just after that, they acquired 1,000 patents from IBM. 1,000. Can you imagine the portfolio of IBM? And we were discussing just before our session here, IBM is one of the largest hoarders of IP. And that's something very important. How do you know and decide what to acquire, what to license? And is your business best served by developing your own IP? Or being able to be strategic enough to license? I think as a country, we have not decided on a strategy. I would defer to the professors here and Dr. Sarkar. Do we have actually a strategy for the country, for startups in terms of intellectual property? What would be the method? Do we depend on academia? Do we depend on licensing? Do we depend on licensing from outside the country? Is it from academia we license, or the startups prefer to develop it themselves? Because They are coming out from uh, academia to start their intellectually driven businesses that serve large populations. What would your take be? I'm just trying to make it
It's a-
interactive
it's
so
it's a
that we
bit
start with the right
uncommon
tone.
for somebody to talk in the keynote address. But, since the question is asked, in our country at large, we do not have that kind of a strategy. What we have is a framework with several policies. Now, what you want to make, what you want to license, in big corporates, the decision is quite systematic. It's a decision which goes like build versus buy.
I'm not going to, I'll just stop here because, we're not talking of large corporates. We're talking of startups.
So
And in
that's-
startups, we really do not have, the frameworks exist as a country, but there is no
I
strategy.
totally agree. What is the problem is that with most startup, IP is the last priority. It is an observation. You might also agree with me.
I'll come to that. I wanted to be provoked. Thank you. So,
The founders, the two main problem in startup community I've seen is that when it comes to intellectual property, it's the last priority. I understand there is always a rush and crunch for resource, including money. And that's one of the issues. The other issues is that in most of the startup, the founders get involved in everything.
okay, I'll just come back here. We look at life sciences startup in a very big way. And we insist that you develop innovations that are IP driven. So, from the funding agencies, there is a huge pressure for developing intellectual property because their funding is very innovation driven. Startups in other areas are not so IP driven. So, if you look at the entire portfolio of startups in India, of which life sciences would be about 12% to 15% maximum, because we are talking of maybe 1 lakh startups and we have about 10,000 startups. So 10% is more, but there'll be some more if I take environment and other areas, like even include EV into it. So that would make it about 15%. These startups are very IP driven. The others out of that 1 lakh startup that we talk of, many of them are not. They are in the process of developing businesses. It's not necessarily trade, but developing businesses that would solve a problem. And solving a problem could be of a nature which is e-commerce. Solving a problem could be developing a platform. Solving a problem could be actually providing access to various services and not necessarily based on the intellectual property. Since we have friends from Africa here, I was at a CRISAT yesterday. I would just tell you there. Have you heard of Wave? How many of you have heard of the company? It's a unicorn from Senegal. Okay. So what does Senegal do? Senegal is a unicorn. What does Wave do? It provides financial access to a country and to a continent where 50% of people do not have access to banking. I think we need to look at startups as solving a problem, as solvers of big problems. How many? This is a IP is there in terms of AI model that they have built. It's an AI based company, but their problem is to address the financial inclusion in the African continent, starting with Senegal. If you have heard of M-Pesa, the telecom company, and you must have heard of M-Pesa. So Their role is also, they're a telecom company. Now they're also into financial services. And so these are companies that are actually solving large problems. So the question is, should IP be central to the business of startups? Because that is the topic today. Or is it startups actually are not focused on IP? They are focused on solving a problem. How important is to guard your solution and provide the problem by protecting what you have developed is where all of you come in. And we have to see which of these solutions, and I'll just, I know it's 10:15 and I have 5 minutes more to go. I'll just give you one example. How many of you have heard of a company called Eliminate Waste, where it is written as 8? It's a Israeli-US company. It's a AI-based fruit and vegetable sorters in large conveyor belts, where 85% of the fruits which are good, they get sorted out. What can be shipped for long distances would have to be kept in a different way than what can be given for medium distances in terms of logistics, and which has to go to the local market for immediate consumption. Eliminate waste. It is not focused on IP, though it's an AI-based company. They say we are not here to develop a large portfolio of intellectual property. Intellectual property to them is much more of a trade secret. It's not of filing patents. Their business is to solve the problem of 40% of fruits and vegetables globally that get wasted. So I think we have to understand what startup needs, why are startups formed, and where do IP come in their business, and how do we help them in growing their business. And that is, I think, the crux. If we understand our startup businesses well in India, we will be able to strategize their IP. If we think our startups as large corporations, we will not be able to develop an adequate IP strategy for Indian startups. So, of course, I'm not getting into copyrights, trademarks, and so on and so forth. I'm just talking of limiting myself to IP and trade secrets, because that is where I've seen the maximum leverage that companies that grow non-linearly are able to gain. I would end by saying and asking a question again to all of you. What percentage of startups, and this is unicorn again, and taking unicorn just because otherwise startups are very small, 2% startup to 50 people startup or 1,000 people startup. So just to have a benchmark, you see, those who have grown beyond a certain point, how many of them, percentage-wise, have high-value strategic patents? Patents are also can be categorized as low-value patents, high-value and strategic patents, and unicorn patents, which are really high-value and strategic. So how many would be falling in the second and the third category, and what percentage would be the low-value patents filed for various reasons? Any guess? It's 97% are low-value patents. And that is, I concur with Professor Sarkar's comment that yes, IP globally is not on the top of the thoughts of startups that are building businesses, even those who are building businesses at the level of having valuations that high. So how do we really look at India? Because ultimately we have to think of our country. And since I'm sitting, or I must say I'm standing in front of intellectuals developing intellectual property, my request is, can we actually find out what strategies would work for what kind of domains of startups? Because if I do a flat, broad brush definition of startup, we may not be able to arrive at any conclusion. Can we look at domain-wise what strategy should the country adopt? Thank you very much.
Thank you, ma'am. I don't think we could have asked for a more interesting keynote speech, especially not with the back and forth that we were presented. Now, I would invite Dr. Sarkar to present the mementos to. No, sir, I'm inviting you to present the mementos. Does anyone have any questions that they would like to ask, ma'am, before we proceed?
Is that okay?
Yeah,
Send a mic, sir.
It's all. Okay.
Thank you very much, madam. Please note. My question is, while ending your speech, you said you want to really slice and dice of various startups and strategize what is the right IP model for them,
Domain-wise.
domain-wise. The today's topic is mainly on the startup business. If I look at how the startups works, in general, the people come across, try to find a commonality in terms of their ideology, and after that, try to do some product or service and try to monetize it. In this process, they change the strategy multiple times till they are successful. The company which has just started as a maybe strategy as a services company might become a product company or a blend company, product come service, right? A company started a tech company. Ultimately, they've seen it, the tech usage in some other domain like microbiology. They try to move into that direction to be successful. Ultimately, you have to create an asset, monetize that value, and get benefit financially.
So what is the question?
The question is, having that slicing and dicing domain wise may not really work in that model because every startup is different. Ideology is different. So when we try to look at the startup business, we need to work with them, understand the current situation in terms of what they're trying to achieve. In that particular phase, try to help them in an IP point of view.
Okay, I've got your question. Your question is, of course, we need to do that. This is not an either or thing that we are talking of. Definitely, we as enablers of the startup ecosystem, we work with individual startups. It's not that we do not. But as an institution, I think we need to develop frameworks and strategies. And that, so what you're talking of is technology versus use case. Use case can be medical, use case can be agriculture. The technology domain is AI. And you can have multiple, but that strategy is not going to change. But these are businesses. So this is a complex, this is not a matrix that you're talking of. This is a complex analysis. And I expect an organization like NALSAR to be able to lead that. This is not a two-dimensional or a three-dimensional problem. This is a multi-dimensional problem that we are trying to address. Why we need that? So that there are benchmarks that when we do an analysis of the GII data, the Global Innovation Index nature, we can talk a little more with clarity about where India is moving. Not to say that startups don't need help individually. Of course they need. Each strategy is different, be it a small company, be it a mid-sized company, be it a large company. Thank you.
The student context, what a university is law, academia, and trade can do is more a generalized framework for domains. But when it comes to
No, that we do. That is our bread and butter. We survive because of that. We don't survive because of the research. And that is the domain of this.
I think we can continue over tea on this. Any one
Yes.
more question?
Hello, ma'am. This is Sharad Chandra. So I'm a data scientist working in Google. I have a very general question, ma'am. So everyone wants to start their own business as a startup, and we have a lot of ideas. So coming to the presentation, when we want to put it in the real time, we are not able to do it. So is that a problem coming from the educational routes or the support that we are not getting from the government? So can you give any
So what you told is first part of your sentence is not exactly where you went in the second part. The first part is everyone wants to start because they have ideas. Not all ideas make it to the next level. That is because you've not done the market analysis, not been able to. So need identification and what would succeed is the crux. Get out of the room, talk to customers, do a proper need analysis. Money will come to you. It's not the government who should be funding. It should be people who would see, oh, what a lovely idea. Let me put in money. And from the tech side, there is enough money in the country. Trust me.
But anyways, we have a lot of institutions like T-Hub and all. Even though the success rate is not that high level, man, because I'm seeing very close to the people like who are coming from the elite colleges, from B schools and all. Even they're not getting successful in that kind of startups, even though we have support from the institutions. So what is your answer on that now? It's a very, it's a taunting question for everyone who is.
I would only say our startup ecosystem and our innovation ecosystem in a broader way is evolving. It is not as matured as in some other countries. So we have pockets which are more matured, like Bangalore is a little more matured in terms of ecosystem. There are people who are giving back to the. So I think we need the ecosystem development, and that's where enablers like IKP comes in. We can take the discussion.
Thank you so much.
Thank you.
Thank you so much.
I think we can continue the discussion over tea just after this.
I would now like to invite the registrar to present a memento to Dr. Dipanuta. And now Professor Sarkar to present a memento to the registrar. We will now be breaking for tea, which will be served outside. Our volunteers will guide you to it. First and foremost, I think we would all like this tea break to be treated as a networking session, and for everybody to go out there, talk to each other, exchange ideas, and then come back refreshed for the rest of the speakers who are today. Thank you. Our next speaker, Mr. Sovadeep Sarkar, is the Vice President and Cognizant for Legal and Corporate Affairs and manages IP, technology licensing, legal operations, and corporate affairs for the company. as well as serving on the board of directors for several of its APAC subsidiary entities. He has extensive work experience in the field of technology, IP, and legal affairs. In addition to gracing our IP conferences, Sir speaks at several industry forums, conferences, and workshops, and has to his credit several papers and articles, as well as book chapters in national and international publications. To add, he also has a granted patent. I am told that this is not Sir's first time on the NALSAR campus, but I do hope that this visit turns out to be his best one yet. Sir, if you would please take the stage and educate us about IP management and strategies.
Thank you so much, and good morning to everyone. It's always a pleasure to be in this campus. And thank you to Dr. Sarkar as well as all the organizers. In the next 45 minutes, obviously, I'm not going to speak for the entire 45 minutes. There will be, time given for you to interact and ask questions, and let us try to make this as interactive as possible. So my objective is to cover 2 or 3 points only as key takeaways for all of you. One, I'll cover the general approach on IP strategy. In the introductory session, there was some question asked in terms of, do we have a strategy, do we have a framework, etc., for startups as well as in general. But I'm going to cover the general IP strategy, and then what are some of the approaches at a very high level that startups follow or are recommended as general best practices. I'll not get into specific details around the startup IP strategies because that I understand will be taken in greater detail by one of my friend Ravi in the second half. So I don't want to eat up his session, but my session should be a good introductory, path to his session. So these are some of the areas that I wish to cover, and again, as I said, let's make this as interactive as possible. Now, let's look at some of the studies. One study which was done, though it is not very recent, but it was specifically done in the US, called the Bright Side of Patents for Startups. So they wanted to really understand what is the impact of patents for startups. Does it really impact, or is it just a marketing gimmick, or some patent lawyers wants to make money and therefore will lure the startups to start something on patenting. So they did some studies, and some of the interesting findings that came out, and they did study on specifically only USPTO data. So it shows that the patent approvals help startup create jobs, grow their sales, innovate, and eventually succeed. And obviously, if you get into the details of this study, you will have data points to justify it's not a aspirational statement or an assumption. Then it also suggests that approvals of startups' first patent application increases its employment growth over the next 5 years by 36% points on average, which is also a good data point. In addition, patent grants more than double the probability that a startup is eventually listed in stock exchange, which of course is one of the main motive for startups. And then processing delays impair startups' ability to create jobs, etc. But overall, the study, which brought some insights that patents really impact startup, and that is a takeaway from this publication or study. Now, if you really look at goals of IP management, whichever, it doesn't depend on, whether it is a startup, a large company, or a, whatever type of company, any domain, if you look at, there are only 3 goals that people want from IP. One is, I have to protect my assets, and how do I ensure that I protect? Whether the protection can be in the form of patents, or copyrights, or trademarks, or trade secret, or a combination of all of these. But end of the day, protection is one of the key goals that is there. Now, protection, of course, has certain aspects. It is not so easy. Sometimes when the organization grows big, identifying inventions and innovations also becomes a challenge. So it is the pre-step or protection of how do I identify inventions and then I appropriately choose the right mode to protect all comes under the bucket of IP protection. The second aspect is IP risk management. This is extremely important because while you can do protection, but you also have to mitigate your risks. What are these mitigations? Mitigations, a risk of getting, a third party asserting their patent rights against you, stopping your business, or asking for licensing revenues, royalties, which basically depletes your overall business plan. So you have to, ensure that there is a risk management aspect which gets built into your overall IP goal. IP compliances, ensure IP compliance. What does IP compliance mean? Now, if you look at from the software industry where I come, open source usage is kind of mandatory in the software world. Everybody uses, but ensuring the compliances around open source becomes extremely important. So open source, while it is free, and we have the expert in this country, Biju, on open source, he can talk for days and years, I think, on open source. But if you really look at open source, it is open for public, it is free for public, but it has certain limitations, it has certain conditions, and people fail to read those. It's like we get the agreement and we are happily signing I agree, right? The shrink wrap and the click-through agreements. But end of the day, how many people know that there is a set of compliances that you need to do? There are certain conditions on what open source comes with, what riders. So all of this comes under the aspect of IP risk management and ensuring compliance. So that is the second large bucket which is important. The third, of course, is end of the day, we are in the business of making money. How do I exploit my IP? How do I commercialize? Monetization. Now, IP commercialization, I really like to use the word IP exploitation rather than commercialization, because commercialization sometimes comes with a price, saying that if I want to commercial, how much money did I make? But sometimes in the IP world, you don't commercialize just only for money. Sometimes you do IP for branding. Sometimes you do IP for even keeping your inventors motivated in the company, right? So that is an indirect way of IP exploitation. So you have to look at IP as a broad umbrella, a superset. And there you will have one bucket where you get licensing revenue. You have another bucket which gives you branding advantage. There is another bucket which is more from a defensive purpose. So if somebody is suing you, and you get into a negotiation table with him, if you have certain portfolio of patents, you have a better negotiation power. So sometimes you use your portfolio for negotiation. It's again a form of IP exploitation. Need not be necessarily that you earn money every time, right? Sometimes if you have a good portfolio, you can attract investors and partners to collaborate with you. Sometimes if you have good portfolio, you can collaborate with the tier 1 universities, right? Because they feel that yes, you have invested your time and money into technology and it is worth investing or partnering with you. So all these are mechanisms of doing indirect way of exploiting your IP. IP licensing or IP commercialization need not be saying that how much money did I get end of the day, was I able to add to my top line, right? So overall, if you really look at, these are the three goals, and it is uniform for any type of company, any domain, any industry, any size of the company. However, this is very high level. How do I translate this into activities? What I call it as blueprint. Because at a high level, you can have strategies and goals, but you have to do some activity, right? So these are some of the activities that typically gets done in a company. One, let's start with the easiest one, the trainings, which is ongoing, and you have to train your employees. You have to ensure that everybody knows what is IP. Now, the legal connotation of IPR is different than what people say on IP, right? Everything that you develop is IP, but which is really not in the legal world, but it's okay. Let's not get into the legal definition. But what is important is that every employee of the company should know the sensitivity around IP, because you can protect your IP only if you respect somebody else's IP. Because if you don't respect others' IP, others will not respect your IP, and your IP will not get protected. So it's a mutual, aspect which is very important. Respecting others' IP means I will not download a pirated software, or I will not misuse a third party IP, or I'll not do a copy paste. These are respecting others' IP. If you do it, then only your IP will get protected. Sounds little philosophical, but end of the day, this is all it boils down to. So training is important. Protection, I don't need to specify. It's a standard, all different forms of protection. You should have processes. You should have ways to identify what inventions are coming out of the company, what is valuable, what needs to be protected. Sometimes you may feel that, no, I don't need to protect this as a patent because the lifetime of this technology is very short. Or even if somebody is using this technology, I may not be able to detect infringement, because you can sue somebody only on two conditions. One, when you know that there is an infringement, and number two, when you can get money, right? You don't want to waste money to sue and get nothing, right? End of the day, if it creates a damage for you, then only you will do infringement, right? So two conditions are required. In certain cases, when the inventions are not really worth protecting as patent, you may want to keep it as a trade secret or a very confidential information, because you know that in another 2 years this technology will die down, or other I'll get a first mover advantage. Keep it secret, let only few employees know, and then that's fine. I don't have to waste the money on patenting. So there are different modes of protection that you will have to do depending on the type of invention. Then is IP enforcement. This is a cost. It involves cost if you have to enforce your or assert your patent rights or any IP rights. But you can do it when you are confident and you feel that it is necessary for your business. Okay. Not necessary that you will have to get money always, but you can always stop others, right? Which is prohibition is one of the objective that you can derive, not necessarily a royalty and revenue every time. Then, of course, everything that you do, we should have a clear process, templates. You have to have the right tools and a very strong governance systems around it. And then commercialization models, whether you're trying to do in the introductory call, the panel members spoke about growing your portfolio, inorganic versus organic growth, where sometimes you can acquire patents to suddenly build your strong portfolio, right? Because growing a portfolio from start takes time and money, of course, but time. But if you need a quick way to get a portfolio, you can always acquire patents. You don't have to acquire the entire company. You can always acquire technology patents when they are available, or you can outsource or partner with research institute to create technologies for you and then protect and get the license or take the ownership rights. There are different models that you can do. Partnership model is very prevalent today, because you may not want to invest in all the technologies. So some companies have niche technologies and you may want to partner with them, get some sort of limited license, may not be exclusive, but at least some non-exclusive license. And then you can develop your technology. So commercialization is a very big bucket. And this is another aspect where you need to have real strong processes with a intent of what you want to do. You cannot just copy IP processes of one company to another. Just because somebody is doing X, I have to do X doesn't make sense, because this IP processes or the blueprint is for your company. Like somebody asked, saying that, even in a particular domain, if 5 companies are there, all the 5 companies may have different strategies, because that's very important, because the focus may be different. The kind of market that you are entering may be different. So you have to build your own blueprint. And then risk management and compliance, I talked about. You can have different kind of processes, whether you have IP audits, infringement checks, you have a litigation avoidance processes. All that comes under the IP risk management and compliance. Now, the question I'm sure will be troubling all of you is that, do startups really have to do so many things, and how do they do it? I mean, it's like, by the time, should I build a product or a service, or I start investing in this, then I cannot build a product, right? So this is a typical dilemma that you may have. Now let's look at, in the startup world, what do investors actually look at in the initial stage? And this is where I will pick up the point that Anindya was trying to raise in terms of priority of the startups, right? If you really look at the investors world or startup world, investors look at high market growth with strong, profitability margin. Offering technology, the strength of the offering, right? That's the second important thing that, investors will look at. Strong management and resource strength. Do we have the right skill set? Do we have, a good, management strategy, good leadership? And then what are the go-to market strategies? End of the day, how to make money and how to recover my, investment. What is missing here is there is no IP here. Investors actually may not look at IP at all, because you have not, because that's not the priority end of the day. But the obligations of a startup, founders, do they themselves understand and appreciate the value of IP? If they do, they can actually convince the investors. Sometimes investors are ignorant. So therefore, in your overall proposal, when you make of a startup, you should have an IP component clearly showing why IP is important. And if you don't show it, then the entire investor community does not get knowledgeable in the world of IP, right? So it is extremely important for them to realize that why IP is important. Now, of course, there are certain challenges that all of you will face in the startup world. You have limited budgets for IP. You have, limited time available for IP matters. Knowledge is, very limited on IP. IP and innovation is something which everybody knows, but, the depth is unknown, right? Then you have increased pressure on development revenues, difficulties in protection in the early disclosures, because sometimes in the early disclosures in startups, the details will not be known. So they don't know. They wait for the last minute, saying that, okay, let me finally come out with what is the final most viable product, and then I will protect. But in the world of patents, timing is very important. If you miss out the dates, you're gone, right? So therefore, that knowledge and that when to do becomes important for startups to know. And sometimes the products may not be developed completely. People have a misconception that if you want to file patent, you will have to, have a running product, right? You have to have a product which, because I have also, heard people saying that I'm not filing because the patent examiner may actually ask me to demo the products, and what will I do? So I will not file patents, right? So some of these questions comes up, which is lack of knowledge. Now, why IP is important are some of these points. I think it's known to everybody why IP is important, right? It is protection, risk mitigation, monitoring competition, and, leakage of IP and confidential information. And I'm sure Ravi will touch upon this in his session, where this becomes one of the major conflict in the startup world. Because when two, three people start, they really don't have that kind of an arrangement as to what will be the ownership, who will own what, who is bringing what to the table. And then suddenly one partner goes out, and then you have a dispute in terms of ownership. Some rights may not be properly transferred. You may partner with two, three people, but your IP rights or ownership in the agreement is not clear. Now, when you become big, and then the IP ownership dispute starts, because you have not thought about it. Some employees will go and start doing something on their own, which is very similar to what they have done for you. Now you want to sue them, you want to go behind them, you don't even have an employment agreement which protects you, right? So these are very important things. You should not jump to the world of patent saying that I will file patent. These are basic hygiene that needs to be done first to protect your asset, protect your knowledge, your know-how before you move to the patent world, right? Now, let's look at what I call as the lean IP management model. Now, I don't want to make things very complicated for the startup world, but why I call lean is that you don't have to do everything from day one. And in certain cases, you may not have to do at all certain things because it may not be applicable for you. It's like a mall, right? So what you saw in the initial slide, in the first two slides, where the strategy and the blueprint was there, was more of the IP mall. You have a lot of shops. Now, where you want to go, what you want to pick depends on you, right? And at what stage. So IP is for the future, and that has to be made. It's like an insurance policy. You buy an insurance policy not to get money, right? To protect yourself. And it depends on what perspective you are seeing. I remember this, Gyan session that one of my mentor gave me in the initial period when I started my career and started earning. He said, you can look at your model of earning as present or future. If you are looking at present, then the formula is earnings minus expense equal to savings. That is, if you are living in the present world and if you're bothered about present, that means you earn 100 rupees, your expenses is 50 rupees. And if you remain with 50 rupees, then you try and save. There is another way of changing the formula. It is earnings minus savings equal to expense, right? That is when you're looking at future and you're present as well. When you first save and then you start, spending. Now, of course, as youngsters, we don't want to follow the second formula. The first formula looks lucrative, but in the startup world, I think it's worthwhile to think for the future, saying that how do I protect, how do I leverage and exploit, and then possibly, see at making money. Because if you have done that homework, and if the startup becomes strong, if you have a good portfolio, you will make certain extra money. And most importantly, these will be the differentiators for you in future. Because end of the day, in the world of competition, what matters is how do you differentiate with others, right? Anywhere you go, in a class, every student wants to differentiate himself or herself with others. These are the differentiators, and you will have to find those differentiators which suits your organization. Now, if you look at this lean model, there are three stages I have divided. One is the funding and approval, where the initial, the struggle goes in. Then you have the scale up phase, and then you have the steady phase. Now, in the initial phase, what you need to do is you need to ensure that whatever you are trying to position, if it is your startup is in the technology world, you should not try and do something which is, already crowded, and there are a lot of infringement that happens in that world, and you have done the basic infringement check to figure out that yes, you are not competing in the world which is very, very litigated world, right? Now today, if you look at the litigations that you see in the telecom world, Samsung, Apple, everybody trying to sue each other with the patents world, and if I come out with a telecom idea, right, I will be little bit scared, not scared of not venturing out, but I will have to do a little bit of more homework, because I may be killed in the entire battle, right? So you will have to do that infringement check. Protection will come later. Now you will have to do little bit of a competitive analysis, as I say. Do an IP audit in terms of ownership. Who owns what? What are you bringing on the table? Is it an idea which is your sole idea, or 10 people have got it, or you have partnered with another company to jointly, conceive the idea? Ownership map has to be created very nicely, because that's the genesis of a future problem if you don't solve it. Initial commercialization plan and secure IP docs assignments. And if you're working with third parties, as I said, make sure you get a very clear agreement with IP ownership, reps and warranties, liabilities. These positions are extremely important in the contract. Assignments means that, yes, if an employee has given some idea, make sure that that idea is assigned to the company, right? In return, you can give him something. But end of the day, that assignment is important, because if the employee leaves, the idea still remains with the company. These are basic hygiene work that you need to do on the initial stage. After that, when you move to the scale-up phase, then you have protection as a main idea. Of course, if your idea is developed to an extent in the first phase, you have to protect your idea and file patents or whatever you want to file. But subsequently, if your idea develops further, or the idea changes the track. And this is very common in the startup world, right? You start somewhere and then you have some more ideas. You have a third party saying that, hey, you should do like this. Then it goes into a little bit different world. You have to make sure that your patent that you file is aligned to the product that is there in the market. Because remember, patent is a patent protects the invention only on the basis of what is written in the patent, not what you have developed. This is very important for you to know. I'll repeat it. What is written in the patent is what you are protected. And if you want to sue somebody, you have to sue with the basis of what is written in the patent. You cannot show the product and say that, look, my product and your product is same, so you give me money. What the court will look at is that what is written in the patent, does that map to the product that you want to sue, right? So you have to ensure that your patent and the final product is well aligned. And for that, if you have to file, multiple applications, you have different modes of filing. In India, patent of additions, or in US, you have continuation, CIP, so on and so forth. Those are, technicalities. But end of the day, you will have to align that. That is very important. And then you will have to start keeping certain investment aside for IP, because it's expensive. And it is very similar to insurance. It looks very expensive, saying that so much money is going, I don't know for what, right? But end of the day, that has some value when required. So you will have to start keeping some fund separately for IP, because maintenance is expensive. Filing process is very expensive. Those kind of expenses will, add up. Then you start on the plan of deal positioning and IP commercialization. How do I structure my deal? Sometimes this is a live case I have seen in many startups, that when they license out their product or services to the client, they are super excited for obvious reasons, right? I've got my first client, my first 5 clients. Now the clients take an upper hand. And if you don't have a proper legal expert or IP expert to guide you on the negotiation, you end up giving the IP to the client. And there has been situations where I have seen startups in their first agreements actually have given away the IP rights to the client. And then when I see the agreement, I say that actually the idea is not owned by you. He has actually got the assignment rights from you. And the startup had no idea. Now, if that guy has to sell that same IP, he has to take a grant back license from that client, right? So therefore, you will have to be very clear, not get super excited with the client, saying that, oh, I've got my first few clients, so, let me agree to whatever I want. You have to use your conscience, your, knowledge, or hire somebody to guide you, saying that what is important, what you don't have to get a one-sided, contract favoring where all the provisions are favoring you. I'm not saying that you may not be able to do, but make sure you have the basic protection in the overall deal position, right? And then finally, it is on the steady state. And in the steady state, you basically start enforcing your IP rights. You want to assert your patent rights, or you want to sue, you want to send a notice, whatever it is, you have that power to do that. Then you start looking at building your portfolio, acquiring patents, as we have seen in the past, in the morning. You can also look at premium pricing, saying that, okay, now that I have a portfolio of patents protecting my product, can I charge a premium, right? You see those patented products, they are charged premium, not because the cost of the product is high or cost of building, because there is a premium associated with those kind of patented technologies. And then you can look at partnership model, etc., etc. So overall, some of the key highlights is that investors watch your IP strategies. Investors who are knowledgeable in IP will look at your IP strategies and approaches. Your IP investment initially can be low. There is no harm in that, but it should be a mandatory component in your overall cost sheet. If you delete that line item and think that I'll do it later, you may be late in the game. Trust your IP partner and select your right IP partner, which is very important, because you may not have the knowledge, but you can develop knowledge, but at the same time you need expert, because this is a very complicated field. If you get into the legalities of the IP, it is very complicated. So therefore, you will require expert, get good one who are ready to support startups at a low cost, and trust your IP partner. And focus on IP management strategy overall. And what I say is ignore what the rest of the world may be recommending. As I mentioned, that every startup is different, and therefore every IP strategy may be different. You don't have to copy paste a strategy from one another. And last is very important. I'll repeating: do not keep IP management for steady state. It may be too late, right? I think this is all I had in terms of my presentation. Now let's see if we have some questions.
Excuse me. This IP, whatever is registered, it will have validity for some period of time.
Correct.
After that, people will get imitated. They will imitate that this thing, and then they will try to make money out of it. Whether the original IP owner, whether he can renew that, so that he can prevent others to imitate.
No, you cannot you cannot get an evergreen protection, right?
No, not evergreen. Maybe after some time it can be renewed.
No, you cannot do it. See, every form of IP will have different tenure of protection. Now, 20 years if it is for the patent, that is a good amount of time, which is enough for you to get that limited exclusive rights. Now, in a trademark world, the time period is different, but the most important part is that you cannot go on extending, because at some point beyond your time period, you will have to
maybe with slight modification of the present
correct.
patent,
Now that
we can get it modified, and
you can do that, but it is not that you can go on filing the CIPs etc. and go on extending your entire thing.
maybe for some reasonable time, maybe instead of 20 years, we can go for 40 years or something like that, so that the cash
No,
flow, whatever,
unfortunately, no.
that's not possible.
Yeah, you had a question.
A couple of questions.
Sure.
So first one is more of the right question, AI, and let's compare and contrast that with. Let's compare and contrast that with the open source culture. So how complex has the legal dominion got into that? And the second question will be more on the commercialization side of things, in terms of IP commercialization. As a legal counsel, how would you approach that to the founders and management team?
Okay, I'll take let me take the first one. The first one, you want to understand the interplay between AI and open source world, right?
Yeah, how protection around IP works?
Yeah, so see, the AI world, obviously, whether it is AI or generative AI, both are slightly different, but, let's not get into the technicalities of AI. But what is important in the AI world is that it is an evolving space. Okay, now in terms of protection, there is no different rules that is established for AI from a legal protection. It's the same standard approach that you need to take. However, it becomes little bit tricky because in a generative AI scenario, there are discussions and obviously some case laws are also evolving, and recently there has been a judgment in the UK court which ruled against whether the machine can become an inventor, because in a generative AI world, the machine is generating something, so therefore can they be called as a AI. However, what is important to note is the infringement scenario has become little complicated. For example, when you develop an AI, a generative AI develops something, whether that infringes on somebody else's right is unknown. Because if I am writing a custom developed code, right? Now, when I write a code, I develop 10 lines of code which is custom developed by me. Now, the next 10 line of code, I go to GitHub, which is an open source repository, and I pick up those lines under some license and I put it. Now, what is the ownership of those 20 lines of code? The 10 lines is owned by me, the 10 lines is not owned by me. This is an open source and I'm supposed to disclose it, that these are open source. But I'm fully aware of those 20 lines. But when I give this to Gen AI to develop this, I'm not aware from where he's picking up, right? The big other aspect is The training data becomes very important in AI because you have to AI engine, you have to, train the data with past, train the model with past data. The past data that you put in that AI, whether that data is owned by you or a third party, and whether that third party has given you rights to train that is also unknown. So this becomes a second complexity. There is a third complexity. If you know one of this tool model that has come up in the AI world is called GitHub Copilot. Okay. Now, what does GitHub Copilot do? GitHub Copilot basically sits on GitHub. And because GitHub is a large repository, one of the largest repository of open source code, it actually has developed a Gen AI model to develop code, right? So if you install GitHub, I have personally used GitHub, so I know where if you type it, the recommendations will come. Okay. Now the recommendation comes in two ways. One is they have a switch saying that, so recommendation comes in, in a manner that this particular code is picked up from this source. They give that. And there is a toggle that is there. If you disable that toggle, then it will not search the third party at all. It will not give you recommendation of third party, which gives you an additional protection. But it is not 100% foolproof. Even Microsoft says that less than 1% chances of error may be there. So some of these aspects on the infringement world or in the ethics world of AI becomes very important in the AI, and it is evolving. So I'm sure we will have more complexities coming in the AI world. But yeah.
Before you jump into the second question, I have something following up. So there's something called AI sandbox that's come in the EU, right? Especially with the AI Act coming through there. So they're talking about tampering with AI in a closed space, right to the regulators itself there. How much of a complexity with IP is that right now?
No, it will be very complex. See, the problem with this is that, if you look at, see, every country is now coming with a regulation. Even China has come out with a regulation, and, it says that is one of the very comprehensive regulations. EU has come out with a regulation. Now, it becomes complex. The reason is because one of the aspects which people are a little worried is that if you take a decision based on an AI model, and if that goes wrong, who is accountable? Right? For example, you have AI models which has the ability to screen profiles and select candidates, right? Based on lot of data. So you have the CV going in, and then you have the social profile of the person. So everything gets monitored, and the AI will say that, okay, these are the 10 shortlisted candidates. Now, let's say the AI model is made in such a way, or it gets designed in such a way through the evolving data, that it creates a discrimination among people, saying that, I'll take, this category more than this category, then that's a discrimination, right? Who is accountable for that discrimination? That becomes a more complex area than the sandbox IP issues.
I'll have a chat with you later on this.
Yeah. And the second part of the question is commercialization. My 2 lines of advice will be that I cannot have a standard answer given on commercialization unless I see what we want to commercialize. That becomes important. Saying that if somebody is coming to me for a legal advice on commercialization, I'll have to understand the product, where the market is, what work has been done, what is the kind of protection, who are the competitors, what is their portfolio of patents. Then only the commercialization plan can come. So it's a complex process, but it's a very standardized process that, you need to have certain inputs before you can suggest, saying that these are some of the potential risks, and these are some risks that you can mitigate through your contracts.
Perfect, Shobhit. Thanks a ton.
Yeah.
You said IP is a complex process.
One sec, we'll take.
So thank you, sir. I'm Ankita and I'm pharma consultant. I'm working for a market research company. So the previous question totally relates to us. So what I just want to, my question is simple, but before that, I want to give a scenario. So for example, we are providing the data that how many drugs are being patented in last 20 years. We are having our own database, and we are doing that. We have built our own benchmark model. Based on that, a company can the clients who are the pharma companies, so they can predict that what is the phase transition, what is the success rate if a particular molecule will be launched, and what is the kind of revenue generation based on that. So everything is there. Till now, it was very safe because we have benchmark our own data. We have built some kind of values based on that. We are giving some kind of ratios, success rate, and everything. Now, as the AI has came up, so there are full chances that our clients who have the subscription to our own data, because we are a SaaS-based company, so they can definitely take the leverage of our own data. They build some kind of machine learning, they apply there, and they build the same model. So in that case, what is the legality should be there? I'm sure my company must be doing something, but that is a question I have. So we are having some kind of data download limits. We do have some kind of data sharing kind of limits as well. But there is a full chances that taking our data only and the client can build their own model, their own predictions, and that can combat our own product.
Correct. So, see, I don't know whether I will be able to answer fully in terms of your world, because that's something which is not my area. But let me try to give you a broad perspective of what I feel at this point in time. One is, if you look at any AI engine model, the heart of the model lies the data.
Yeah.
Right. Now, if your company's original strategy is data as a license or the analysis as a license, now, if data is a license, you can always say that, you can always charge for the data, because that company would need the data from you to build that model. Now, if your strategy is that the services may be affected because he will get the output and he may not connect with you and pay for the data, that may be there. But you can always discuss and, have a contractual arrangement, because what eventually they would require is the data for which is precious. So that, of course, data licensing works very important. And in the AI world, data is hard.
That's true. That's true. And my another question is, so you have spoken that there are some kind of in the startup business with the dynamic business, the idea keeps on changing the
Yes,
track,
correct.
and based on that, the patent should be aligned with it. Then how frequently we should patent the idea, because when it keeps on changing with the dynamic consumer requirement, then how soon it is required that we should patent our idea, and on what claims we should patent, how much claims can be same.
But see, there is the parent patent that you file in the initial stage. You can now, if the incremental innovation comes, depending on the scope and depth of the invention, you can decide whether I need to file another patent or I file a continuation of the earlier patent, or I don't need to file, because it may be, see, sometimes what happens is that you take the product to the client would want some customization. Now, those customizations may not be new inventions. It may be just configuration changes. In the software world, you go to a banking software, you take it to a particular bank, the bank will say, I need a logo, I need the first screen should come like this. Those are, we call it configurations. Now, is it innovation? Can you file a patent on this? No, of course. Why will you want to waste money? Now, if the invention, the core invention changes track, then that time you decide whether I want to file a continuation or I want to file a fresh application. That is where it requires experts' advice.
Yeah. Thank you so much.
I think we'll take. You have a question? I'll give last priority for you.
My question is very simple. I know the question is very boring. We keep on talking on the AI because that's a trending thing that's going on. But in 27 December 2023, the New York Times sued Microsoft and OpenAI for using their copyrighted content. So if everyone is aware of that, they'll try to protect their content and will not have the data to feed the AI models. So if I want to start up a company using that data, so if they charge royalty for using their content, I may not be able to pay them. So in that case, what should I do?
See, data was always there as a license only. We never bothered.
Okay.
Nothing is free in this world. If you assume in the IP world it is free, it is wrong. Now, why now people have become very cautious? Because they know for AI you need data, right? So now the eyes are little bit sharper, saying that who is touching my idea? See, for example, data scraping. It's a very, very complicated topic in the legal world, right? Is it allowed? Now, data scraping means I can go to a website of my competitor and I can read content. I can see what changes they have made on a hourly basis, and I do monitor and do this. Now, if I use a tool to do this, it becomes a little complicated, right? Because there may be a term saying that data scraping tools are not allowed in this website, right?
So based on your suggestions, does Microsoft OpenAI doesn't know whether they shouldn't use the data?
No. They may know, they may not know. So I have read this news, but I have not gotten into the details. So I may not be able to answer specifically for that particular question. But my key takeaway for you is that in this AI world, if you are using somebody else's data, look at the restrictions, because now people will change all their disclaimers and all the terms and conditions. Every contract is getting revisited today, because it is not just about data. The new data that gets generated, can you feed it back to the AI engine, also has a problem, right? Because AI engine will become stronger as you go on feeding data, and then only it becomes more stronger, right? Now, if you have developed something for your client and that data is owned by the client, you are not supposed to feed in that data to AI without the permission. In the earlier model, pre-AI, nobody really bothered, as long as you don't commercialize that. But today's world, the terms are different. So my only takeaway is that please read.
Nothing is for free.
Nothing is free. That is historical thing.
Thank you so much.
Yeah.
So,
Okay.
So my name is Murali. My question is simple one, but yet important.
I don't think I can hear you.
If a startup has an innovative idea, and how to choose the right IT partner? How to choose the right IT partner?
Oh, how to choose the right? I think I got the question. Okay. So the right IT partner, see, you will have to get some contacts in terms of, there are of course a lot of facilitation centers, and I'm sure, I think there is some session on the in the afternoon. Yeah. So they will be able to guide you, and they will be also able to suggest if at all you need someone else to advise and guide you. So you will have to look for these facilitation centers who will be able to guide you. That could be the first step. Okay.
Hello, sir. I'm Soumya Raula. We came with our team. We represent a company called Denorlin. We're an incubated startup at T-Hub. We have received our patent 1.5 years ago. So I have like two major questions. If at all, like in the near future, when we want to expand to other countries, be it neighboring or big markets, what are the stats, or like how sure we can be like our information or idea can be protected? And the second question would be like what you recommend, do we need to file separate patents in different countries, or we can have a global patent, like we can update?
Okay, this is patent 101. So if it is, I think you have lost the right to file it in other countries because it's late. However, in terms of strategy, there is nothing called as world patent. Okay, you cannot expect one patent to protect you everywhere in the world. You can do a filing in different countries depending on where you want to protect, or you can get into what we call as the PCT route, where you can, you get a longer period to actually decide in terms of which country you want to protect. So if you have more countries, it's a cost-effective process. If you have lesser country, you can choose for, direct filing. Now, this is what I call as the initial stage when I showed, right, in terms of where to protect. That planning has to be there. Now, if you start thinking on the IP later on, these are things that you will miss out, right? Because of course, you can always challenge me saying that sometimes I don't even know which country I will get into, right? So these are some of the challenges that you will face in terms of, I don't know, I did not know this is an opportunity that came. But as far as if you start planning, if you start thinking around these lines, then it gives you a better advantage in terms of, taking these decisions.
Having already generated Indian patents, so how far it can protect us, when we venture into?
It will protect only in India.
Okay.
But it will also not allow somebody else to, patent that same technology in other countries. So it is not that, somebody will copy that and then file it again in another country, because that you have created that prior art for the world, right?
So just one quick question. So just you mentioned that you have been already late because it seems like almost 1.5 years we received a patent. So like what can we do now, like to make it more secured and keep it going?
Can it,
Particular agreements, if they are doing the mark.
yeah, it is only contractual agreements you can do, but patenting you can, nothing.
In other countries, you say.
File more patents. You can also do a defensive publication so that others can't file.
That anyway you can do it.
That could be a.
Yeah, but the only thing is that this patent publication becomes a kind of a prior art. Well, you don't really. So maybe we'll talk offline. Let's see. I don't get an idea immediately.
Sure, thank you.
Okay, I think one, and then I will move to you. The session ends with your question. Yeah, sorry. Ah.
Because startup is lesser resources in terms of money, time, and etc. Need to deal with.
No, but then the point is that you don't need to worry. The reason is when you file, your date clock starts. So the protection is there from the date of filing. Let it take the process. And I think there is one process which I don't know whether expedited patent examination is a process which is there, which takes a little bit of extra money from the patent office perspective. Huh? Yeah, that call system. Correct. Correct. So that you can avail. Yes.
Second thing is what we expect from government to make it more easier, okay, of a patent filing. Because
See,
the government expecting 2 lakh patent a year in the next.
Correct. So you have government benefits on patents, plus you have benefits given by different facilitation centers, different trade bodies.
These are like proven stats.
Pardon? Sorry, somebody. So we have a session on that. So I think that will get covered. Okay, Anindya, your question, and then we end up the session.
Well, I do not have a question. I just want to give my 2 cents.
Sure.
Okay. It was just yesterday that in Hyderabad itself, I spent the day on a different conference on AI and emerging technologies. So I thought I will share a few points. See, governance of AI or the use of AI or the deployment of AI is really a challenge. Do we have laws? Are all countries aligned? No. Each country are looking in a very, very different manner. As of now, it is only China and Israel who has come out with laws, proper acts and statutes that this is how AI should be governed. UK and US are of the opinion that they do not need laws. They have come up with frameworks and policies. Countries like Canada and India are working on such policies. Some of the white papers are out for comment. Okay, so that's how the governance structure of AI is currently. Secondly, when you talk about governance of AI, it is not only governance of AI. AI is not about working in what you say, it's in silos alone. We need to talk about data protection. We need to talk about privacy. You need to talk about IP laws. You need to talk about product liability laws. You need to talk about consumer protection law. You need to talk about antitrust and competition law. None of these laws are in tune to handle the emerging AI systems. However, having said that, you should also appreciate that the law has always been a follower. It is technology which is the forerunner. You cannot have a set of law or statute ready for tomorrow's technology. The technology in this area is changing in such a high space, such a high speed. There is going to be conflict. There are going to be gray areas, and some of the case laws will help us to define those. So these kind of statutes will come in. Having said that, in another last comment I would like to make is that when you're using AI, there are some intrinsic risks. It doesn't matter you're using for what. The first risk, these appear theoretical now, but we're moving to that question. The first risk is that, the fear of a, what do you call that? Super intelligent AI, where you may lose your control, and non-alignment of AI with human values. The AI doesn't think in our way. Then this can be highly used, misused, and abused in military AI. Think of a strategic decision on AI. You look at global governance, which is being pushed by AI. It is totally clear, not clear. Then there are several uh, ethical and regulatory issues. Ethical issues like there's no transparency, there's no explainability, autonomy, there could be bias, which you pointed out, or fairness, whichever way. Then dual or multiple use of an AI. If you look at the regulatory, what are the safety and points? What are the certification grounds? How do you handle public input and accountability? And most neglected one is there could be oversight of autonomous system, which already happens, and we have legal limits to handle that. There could be unintended consequences. How do you manage disaster? Is there a contingency plan? How do you monitor, audit, and take care of third parties? So when you talk of IT, AI, emerging technologies, it is a lot much more. I just thought of sharing my thoughts and giving my two.
No, absolutely. I think
I'm sorry if I was included.
No, you're absolutely right. And, this is something which, I have also noticed that some of these AI models, the LLM developers, because of the level of uncertainty that is there in the AI at the moment, they have their contracts structured in a way to protect, because it's not that you will feel that, this doesn't give you any protection. Okay. But there is nothing that they can do because it's very uncertain at the moment. We don't know where it will lead. But eventually it will all get, in a steady state. If you recall, when GDPR came on the privacy front, everybody had a chaos, right? But then eventually GDPR has settled down, right? So I think AI will also settle down. It's just a matter of time. Many things are unknown at the moment as well. Okay, I think with this, I'll end my session. My time is also up. Thank you so much. I think this was very... Okay, one last hand. Yeah, very quickly, if you can ask.
Am I audible, sir?
Now you're audible, yes.
So, at the conference has been given an awareness to IP on the startup business.
No, just you can take the mic.
Thanks for giving an opportunity to create awareness on the IP, especially in the startup level. So, being myself as a startup business person, I would like to take all these prospects in daily level. I want to give one example. If you go to one very good shop, that shop could have some bracket on the board. Say we don't have any other branches. That is one kind of point that they want to say that their IP, property rights in terms of conveying the people that this shop only has that trademark like that. Similarly, the publication time in the per patent rights and other thing, the protection values of the particular startup business has given a drive into their products, like the time taking process, which is the only reason everybody is not interested to do the patent. That is the only reason. And the policies and implementations given by the government, the dragging process. Here I want to do two projects. I want to go for patent. I applied for twice, especially in lithium electrical bikes related. So I have to wait it for 18 months to get it my file numbering. So this makes me to take back step to do my business first. Let me do my business. Let me grow myself. Later we'll think about the patent. Can you give any suggestion?
So this 18 months to get a number, I don't understand why, because
They said that there are 2,800 applications are there in electrical bikes related lithium ion batteries. So all the products from the lithium ion batteries are main sources are imported from China.
No. I think can we take this question offline because I need to
Okay.
get into some more details and before I give you a please, I will
I
be
just
happy to
want to
speak.
say that
Yeah.
the time taking process for the publication is as
Let,
make me
let
to
the publication take time. Your filing date is important.
yes.
So you file and you can not forget, but you're protected.
Yes.
So that is important. Let it take 18 months to publish. Let it take 24 months to get a grant. Doesn't
Yes.
matter. We'll talk in detail. Thank you so much.
Thank you, sir, for all that. I think at the end of this day, the one thing that cannot be said about this conference is that it was not interactive. So thank you everyone for participating. Next up is Mr. Biju K. Nair. He is the founding partner of Legal iTech, a technology-focused law firm. He has been involved in open source license enforcement in India and drafting open source policies for various entities across the globe. He represents Open Intervention Network and License on Transfer Network, which are global patent non-aggression communities in India. To add to this impressive list, he is also a mentor at German Accelerator, Founder Institute, and International Trade Council. So, if you could please take the stage to tell us about open innovation as an IP strategy.
Good morning, everybody. Thank you, NALSA, for the opportunity. This is my first time in NALSA. So, the topic I'll be talking today is open innovation as an IP strategy. So, we have all, from the morning, we have discussed IP from a different perspectives, management, and all those issues, filing and stuff. So, today I will be talking about a different perspective because as companies, as startups, we look at IP from different perspectives. We all think that, okay, we should have a silo mechanism of IP management where we do everything in-house. Whether you are a startup, you are a company, where you yourself do the patent filing, you also do, product launch in the market, you do everything in-house. But is that the way forward? Is that the way you could do things, or you can do a better way of, IP management and IP strategy? What is open innovation? Can we think of open innovation as a different strategy, which we have been looking at from a closed innovation concept? So what is open innovation? So you can define open innovation as an ecosystem where ideas flow across boundaries. So it is not just your company, you're interacting with universities, you're interacting with other startups or companies, not just in the country, across the globe. And in also from different verticals of industries. So let's say you are in life sciences, you're also interacting with software or ICT companies. So you are not limiting your boundaries because one product of yours or service of yours could have usage in different sectors. Like for example, drone. Drone I can use in agriculture sector also. I can use it for military warfare. I can also use it for medical technology where I can ship that medicine in the remotest part of the world. So in that light of things, whenever you make anything, please look into what and all boundaries you can cross with that, because that is very important. So how do you define open innovation? So this is a Professor Henry Chesberg. He has defined open innovation as is a paradigm that assumes that firm and can and should, this is very important, use external ideas as well as internal ideas and internal and external paths to market. So there is ideas, there is internal and external markets, and he says that firms can and should to market as the firm look to advance their technology. So markets is very important. So market can also be looked in from different perspective. Let's say the same drone, you're looking it only from healthcare perspective, but that's a different market. Then there is geographical markets. So all these parameters should be looked into when you look at open innovation. So what was the thing which was happening before this? And how different is this from an IP perspective? Because when we look at IP, we always think, okay, I will file. So the word is I. When generally we look at IP, okay, my company will file. We will not file. So when the difference is, innovation has to be looked at from what and all the traditional concept of innovation was. I will file, my company will file for patents, my company will enter into the market, everything is I. Now the approach is different. So that is the traditional concept of IP. So this is contradiction with, on the face of it, you will feel that this is different from IP, because how can open innovation and IP go hand in hand? Because they are little different. But that's how companies today are doing work, because you are limited by resources. You may be the biggest company in the world. You may have the maximum amount of human resource to develop things, but everything is limited. So if you do an open innovation methodology where you are taking help of universities, you are taking help of startups, you are not just in your geographical jurisdiction, but beyond your country, you are working on various ecosystem players to use of those technology you have innovated, and also take help. So let's say again the drone technology. If I was a healthcare company who had done that drone, that same thing could be used by agriculture sector, because the same capacity can be used in different other sectors. So I can monetize my IP in different ways. So it is very important that we look at IP from a different perspective, which is an open innovation methodology, where I look at IP from IP and open innovation as a hand in hand. It's like left and right hand of yours. So both should coexist. And how can I make maximum money? So in my presentation today, you will also see, I will take up examples of companies having silo thinking, and what did they achieve, and what other companies achieved because of their innovation. And also we will see practical stories where companies have benefited from others' products and others' innovation. So open innovation implies a willingness to allow knowledge produced within the firm to spill over to others, and possibly with the exception of receiving knowledge spillovers from the others in return. So you are giving something, what you have. You might be expert in one area of technology. Let's say you are in chemical technology. You are expert in that. But I might need that chemical technology if I am in water management. So we can, do a cross licensing with each other and benefit. And you might also have a market because of me. That chemical technology which you had, I am the market for you because I am in water management. So this open innovation helps you in that manner. Not for the geographical market, this also is a cross market. So typically, when you say IP protection, we talk about excluding the use of knowledge to others. You exclude others outside the company. So now we will look into the two types of ecosystem. One is your typical closed ecosystem where, one arm doesn't know what is the other arm doing within the company. And we don't know what is happening in the universities, what is happening in the startup ecosystem. So that is a closed economy, closed ecosystem. And the other ecosystem is the open ecosystem. So the most important fact here is both collaboration and competition is happening in this ecosystem, if it is an open innovation ecosystem, because you are collaborating on fundamental technology and you're competing on your services. Like we all use Android phones. So that's the best example, because companies like Google own some of the patents, but they don't fight with each other on the patents. Everybody can use today Android and you can build things on top of it, but you make money from the services. So cooperation is happening on the fundamental technology and competition also is happening on the services. This was not possible in the closed ecosystem. What would be a typical closed innovation ecosystem? We will hire the best, so that the smartest people in the industry work for us. We bring new products and services to the market. We must discover and develop them ourselves. Everything is ourselves, silo thinking. If we discover it ourselves, we will get it to the market first. The company gets an innovation to the market first, usually wins. So these are all the mindset of a closed innovation ecosystem. If we lead the industry in making investments in R&D, we will discover the best and most ideas and we will come to lead the market as well. So all of this are the closed innovation ecosystem. We should control our intellectual property so that our competitors don't profit from our idea. So let's look into this from the modern perspective. Can we be in a closed innovation ecosystem? Shouldn't we, collaborate with others and see, because we can benefit from them? So now let's look into the open innovation principles in contradiction to the closed innovation principles, where we also have smart people in the company, but we also will collaborate with smart people outside the company. They might be in Japan, they might be in US, wherever they are. Internal R&D entities also will work, they will create significant value, but we will also claim the value of others, what has been generated. So it could be, you have filed for patents, but you will also buy patents of others, or you will license patents of others. Or you would also work in a collaboration with academic institutions like this, or you would also work with startups and do co-creation of IP or co-development of IP. Because let's say I am good in chemical industry, you might be good in water management. So we can collaborate. So the value, as we talked about it earlier, the resources are limited. So how do you manage those resources? Whether it is people, whether it is financial resources. So you should have the best of the external world and also the internal world. Doesn't mean that your internal, you will not have an R&D team. Doesn't mean that. You will have an internal R&D team, but you will not be spending so much of money in the internal R&D team that you're also not taking the help of the external members outside the your boundaries. So now let's look into what are the closed ecosystem, innovation ecosystem, and how does an open innovation ecosystem differ. So I'm also not saying that we should not have a closed innovation ecosystem. Some entities, some sectors need a closed innovation ecosystem, like pharma for that matter. So what is the difference? So if you see nuclear reactors, mainframe computers, these are closed innovation ecosystem generally. Largely internal ideas, low labor mobility, little VC funding, few and weak startups. Universities are unimportant to a closed innovation ecosystem. But if you see an open innovation ecosystem, you will see PCs, personal computers, movies, many external ideas flowing. High labor mobility. You will have consultants from other companies. You will have consultants from universities working with you. There is an active VC funding, because VC is that you are working with various entities and your potential or your capabilities are shown in those entities. There are numerous startups you're working with across the globe. Let's say you are in high-tech industry, you're working with entities in China, you're working with entities in South Korea, US, Israel, So you have the understanding and the benefit of all these companies across the geographies. And you're also working with universities. So if you see many of the universities in US and other parts of the world, they are also the biggest contributors to patents. They are one of the biggest patent filers also. So you would benefit from all those things. Otherwise, you would be, sometimes product market fit also you don't know, because the value of your product also you don't know, because you may not think of a cross application or dual use of that technology. Because let's say you are in healthcare, you don't know about what is the value of that product or that innovation in other areas of technology. So it is very important that you have a open innovation ecosystem in place. So now let's look into the virtuous cycle. It's taking time. Yeah. So typically, this is an open innovation. How do you manage the R&D? So if you see, the research and development teams are working together. The research projects are collaborating with the development teams, and also they are looking at beyond the boundaries of the firm or the entity you are working with. They are looking at new markets. They are looking at the current market. So there is a huge flow happening in the whole screen. So research projects are, talking to the development teams across other boundaries of the firm with new markets. You're also looking at what is the current state of your product. So you have an understanding that what is happening with your product, what is the usage, what is the cross usage, because other companies can also look at this technology and see what is the value for them, whether they can benefit out of this. So this is how it would happen in an open innovation ecosystem. But if you look at the virtuous ecosystem, I don't know why the slide is not showing up here. But if you see, that will be a silo ecosystem where you are spending money on R&D. There is no cross, talk with other R&D teams across universities, startups. There will be no interaction with on marketing. There will be no interaction. Everything happening is internally in silos within the company, within the boundaries of the company. So that would be a problem. So now let's look into one of the best examples of a closed innovation ecosystem. So this was the story I was talking about. So Xerox had the Palo Alto Research Center, one of the best research centers in the globe. They spent resources, huge amount of resources. They had a vision to launch a brilliant R&D center, 30 years of continuous investment. They had the best practices in the world. And if I tell you, there were 24 companies which were spin-offs from Palo Alto Research Center. Adobe is one great example. There are so many other examples, 3Com, Grid, and 24 companies like this. And the Microsoft MS Word, the predecessor of that was Bravo word processor. So that also is coming from the Palo Alto Research Center. The user interface in Macintosh also comes from the Palo Alto Research Center. So everybody benefited. They also benefited. But the problem with this methodology was it was a closed innovation ecosystem. Huge spending, but the company did not benefit from that. It was others who benefited from the closed innovation ecosystem. So it is very important that doesn't matter that you just invest. You do have a thought process, you have the best practices in the world. But if you can't have an open innovation ecosystem where you can reduce your cost on resources, both human and financial resources, you can also learn from the the market. Whether your product, if you interact with other ecosystems, they will have a different use case for your product or your services. So it is very important that you look not only internally, you look externally. So a closed innovation ecosystem is that you're looking at silo thinking. That's a silo thinking. That's a silo mentality. And as I said, there could be some sectors like nuclear energy. You have to think in a silo ecosystem. But in other areas of technology, please have an open innovation ecosystem. You benefit from a lot from the advantages others have on the table. You bring on something on the table, they also have something on the table to offer. There could be a market which you would not have realized. There could be a use which you would not have realized. There could be financial resources they might have, or they might have patents which you don't have. So there is a lot of advantages in various scenarios, and especially high-tech technology, where things are changing so constantly that you need a open innovation ecosystem. Now, let me go to the next, example, where, so I am also a representative of Open Invention Network. This is the largest community in the world, which looks at protecting Linux and open source. So when I use the word Linux and open source, we are talking about 3,885 softwares and applications. Android is one of them. So what happens here is, we are providing an ecosystem where there is cooperation and competition at the same level. So let's say we have 4,500 members, startups, companies, non-profits. We also have universities like NALSAR, where everybody comes together on the same page. So it's a defensive patent strategy. Anybody can join. You are a startup, you are a project. You join, the only commitment you have is that in case you have a Linux platform patents, you will not assert it against the community members. And you have a reciprocal pledge coming from them. So let's say I'm a small startup, which was started yesterday, let's say. I am part of the community. There is no commercials to joining the community. You join the community, you get a reciprocal pledge. So IBM, which has the largest collection of patents in the world on Linux and open source, is part of the community. They initiated this community. So anybody who is part of the community will not be sued by the community members on Linux and open source. So there is cooperation on fundamental technology, which is Linux and open source. And there is competition. Let's take the example of Google. Android is one of the 3,885 softwares and applications. Google, being part of the community, cannot sue any of the community members on Linux and open source. Here it is Android. And what does Google get in return? Google also will not be sued by all the community members on any of the Linux and open source patents they own. So as I said, IBM has the largest collection of patents on Linux and open source. So IBM also will not sue Google. So on fundamental technology, there is cooperation and there is competition on the services you provide. So Google makes money from the services it provides on top of Android. And there is another advantage. If it is on open source, there is more users. So more users, more adoption. If you have filed it as a patented technology, sometimes there may not be adoption because the cost of licensing is too high. So here, everybody is using it. So Google makes money from the services it provides on top of it. So it's not just Google now, it has used this methodology. Tesla has open source all its EV technology. Toyota has open sourced its EV technology. The basic thought process, to my understanding, is that more users, more money. If you have limited users, and there will be lesser adoption, and there will be less contribution. So it makes business sense that more adopters are there, more users are there. They will also fine tune the product or the services or the software. So that's the benefit of, so if you see, it is not just in one technology. You will see whether it is automotive grade Linux, that is the infotainment system in your car, or whether it is cloud, whether it is drone, whether it is encryption, whether it is mainframe, whether it is anything you can think of, computing, anything you can think of is there. Tizen. So you would have seen Tizen phones and watches. Samsung and other LG are some of the contributors to this project. You can think of anything in this world, there is something or the other on Linux and open source there. And there is collaboration happening with startups, institutions, academic institutions, projects. So now let's look into the open innovation ecosystem from a different perspective. So you will see automotive companies collaborating with each other. So whether it is, so these are all the members of OIN. You can see US entities like Ford. You can see German entities like BMW collaborating on fundamental things which like patents. What are they doing? They are saying that we will not sue each other on Linux and open source. This being fundamental technology. We will cooperate. So the concept is called co-option. Cooperation at the fundamental technology and competition on the services. So this is a new term which you can't generally think of in a business parlance because it is different from your traditional concept of cooperation with your competitors. Are you nuts? That's its a typical concept. No, why should I compete? Why should I cooperate with my competitors? But everybody on Linux and open source, all these members are collaborating. So any sector, you can see, leave the geopolitics. You can see Alibaba, Baidu, Microsoft, and SAP. We know the geographical tensions. But despite all those things, companies are collaborating. So you will have, from Indian ecosystem, you have Wipro, L&T, Mindtree, Infosys, all collaborating on fundamental technology, which is Linux and open source here. Across sectors, medical, retail, semiconductors, hardware, telecom. So as we discussed, what is happening is on high-phase technologies, there is collaboration. The benefit of each other's, like IBM has the largest collection of Linux platform patents in the world. Google has Android. Toyota is also collaborating with them on automotive grade Linux. So everybody gets the best of each other. There is a joint working with in various open source projects, like whether it is automotive grade Linux or Android project. There is collaboration, there is investment, there is new markets being understood and benefited by each of them. So cooperation is on the lower in the stack of the technology and also in the core technologies. And as we said, on the services you make money. So it's not that there is just collaboration and cooperation. There is money also being made. So open invention network becomes the fundamental backbone to ensure that there is no patent tension. So if you see here, from times, from the Linux, starting of Linux, whether it is Android, Chrome, OpenStack, Open Container, automotive grade Linux, whether it is Hyperledger or LF Energy, everywhere there is collaboration happening. So broadly now, I think, yeah, some questions. Ma'am, I'll come to you. Don't worry. Yes, ma'am.
So I actually am going to share the three banker focus for pharma because I'm from pharma background.
And we are in the city of pharma.
As I can see, most of this is concerned with the IT.
No, ma'am. Medical devices, retail. So that's why IT is only one of the sectors.
In the sense that away from pharma. Initially, I said I'm going to be completely focused on pharma. So my work here has been the past 20 years. I came back with a PhD in microbiology and I started working in pharma. I accidentally got into this. I started working with different Indian pharma companies. I got the life of this operating. The open source innovation, the open source idea that you are talking about. Right now, is this on? Am I audible? Yeah.
So the beautiful concept that you're talking about is completely lacking in pharma. And yes, you said that it is a closed system for them because they want to protect their things. And I understand that part of it also. But coming from the accessible medicine, particularly post-pandemic, seeing all the situations that were there, why is it that patent pooling that is there in case of other in the other sectors, it's not showing up in case of pharma at all? If I've seen enough number of companies, middle level companies coming to me for consultation. And there are companies which are like from IT to BT, IT meaning IT and BT meaning biotechnology. They tried investing in BT, and after 4 or 5 years, they just basically gave up and said, this is long incubation periods, and investment is going to be a waste of time and everything, and they went on to do something else. So in a scenario like this, there are situations where you have labs that can collaborate and things like that, with whether it is patent pooling or whether actually just licensing, cross licensing and things like that. Why is it that's not coming into pharma? What do you see as a
Ma'am, although I don't interact much with the pharma, but I think many of the technologies could be, like even today the pharma companies use a lot of ICT or, all those, whether it is genome and other areas, there could be a scope for collaboration. So if I see the Indian ecosystem, not just pharma, many of the universities, like we have in the Institute of Science, where 100 crores of public money is spent every year. CSR labs. How many of them are able to license their patent pool or benefit from each other's work? Like somebody was talking about EV technology. There are CSR labs, Karakudi, which does only on that lithium batteries.
Correct.
And we don't get to see the benefit. So, that's why, this concept is very important, that unless we don't collaborate with each other, there could be some things which pharma can help in the, ICT technology, or the ICT technologies can be used by pharma to, produce the medicines or discover the medicines faster. So that's the reason that this is very important, that we collaborate with each other. And cooperate with each other. And we could learn from each other's expertise.
Absolutely. So that the reason why I'm bringing it up is, as it is, most of the biotechnology or any kind of thing that goes into making a medicine from pharma actually comes from universities. Universities are the ones which actually create that kind of knowledge.
The Oxford University's work helped us in the COVID times.
All of California, if you go there, and most of the incubations happen between universities and small industries, small farmers and
the California Institute of Technology has the highest patents.
Yes.
So
that's
that is how people actually in instances in pharma where pharma has supply. So every pharma worth its salt, especially also the pharma, have a very large collection of pharma. So there have been instances where they have to end their chemical license, especially to large projects which have been say started up by Space Foundation. So there was projects on PV medical discovery when many companies actually lent their small molecule.
Correct.
Now, small molecules in the beginning, very easy for a company to say, I'm not making money there. But
Exactly. Yeah. See, that's the thing. So instant gratification, instantly you need to see the thing. And that's actually happened. This is a case that I have practical, since we are talking about practical scenarios, I've seen a very big IT company investing for BT, and within a matter of 3 or 4 years, they just fired their scientists, and they said, I consulted for their IP. and that incubation period needs to go in, and that's not happening. That's at one level. And so, for example, if we take a look at the the COVID situation, and we are talking about the platform technologies that were required, if in a country as big as ours, with the kind of scientific knowledge that we have and the institutions that we have, if we had developed the platform technologies enough to take it forward to come into a vaccine thing, we would have had a better scenario with respect to vaccinations. And so that always comes down to the same point that you are making here. And but it seems to be working with the rest of the things, that patent pooling and everything. Why is it not working with university? Because universities don't talk to anybody else. And there are some government push for patenting, and institutes are really trying to push for patents. Most of them are ending up with valueless patents because their research is going into a different direction and it's not channeled into the required area. So that is another area which needs to be, I don't know whether awareness needs to be.
Ma'am, I think we will give also the question opportunity to others. Yeah. Somebody had raised a hand somewhere there. Yeah, maybe we can continue offline. Yeah. I'm here till evening, so thanks for your opinion. Thank you. I can be reached on email also.
Thank you, sir, for that refreshing presentation. Up next, we have Dr. Janani Venkatraman, CEO at Biomoneta, where she leads strategy and management. She has over 20 years of experience in various fields of biology, with over 10 of those focused on infection drug discovery. She is part of the founding team of Bugworks, a drug discovery company innovating treatments for antibiotic-resistant infections. Previously, she was a team leader at AstraZeneca India, where she helped manage the early discovery portfolio and provided scientific leadership. She has received a PhD in molecular biophysics from the Indian Institute of Science and has trained as a fracture fellow at Yale University. We call her on stage now to speak about her experience at building an enterprise herself. Ma'am?
Yes. While the presentation is coming up, just a few general remarks. First, thank you very much for coming here and listening to me. It's going to be a bit of a shift in the way you think about things, because you've had two very conceptual talks talking about core IP sort of issues, and I'm going to go sort of almost egotistical in my approach and say, okay, here is my story, or here is our story in a particular company, and I hope that will. But our journey has also touched on some of the questions that the audience had brought up. So I'm just wondering if some of our experiences will help answer those questions. But before diving into all of this, just wanted to say, Biomonetas, or my entrepreneurial journey, started about 10 years back, right? And a decade is a good time to sort of do a little bit of reflection and see if you're really on the right path or not. So 10 years back, a group of us got together and said that, what is really important to start a company which tries to make new medicines or new antibiotics. And this was because the world was just beginning to realize that multi-drug resistance was a huge problem, and there hadn't been a novel antibiotic in over 40 or 50 years at that time. All of us at that point, that company was Bugworks, by the way, had worked in large companies and were sort of used to working in these silos with, our own specific goals and so on. But one of the beauties of starting up really is that you get to take a step back and ask, if what I'm making, I'm going to spend X number of years on it, is it really going to benefit whoever it is that I'm actually going to be making all these things for? So we took a little bit of time, and Bangalore is sort of interesting in the sense that there are multiple hospitals which are open to working with startups. I'm probably sure Hyderabad is too. My experience is not over here.
And there was one hospital, the St. John's Hospital, which used to allow startups to come and spend time in the ICUs of their hospital, and asking like, okay, I have a thought, I have an idea, I have an invention. How will this actually benefit a doctor or a medical situation? So I did do that. But and all of us until that point of time, our only experience with hospitals has really been to when you go to a doctor and get treated yourself, right? And you're now sitting sort of on the other side and walking with the doctors towards patients, and day one you really happen to come across we basically observed a death happening. And this was like a relatively young lady. She was 42 years old, just a few years older than me at that point of time, and she had died of a fungal infection. And she had died of a fungal infection not because that particular fungus was something really terrible. I mean, all of us are surrounded by fungi all the time, right? You're sitting in this room. This is a relatively new room, but there are older rooms. You have air conditioning, which sometimes is fairly old, which is all places where fungi tend to grow and thrive, and we're exposed to it all the time. But we're all fine. But this lady happened to be a pretty severe diabetic, and when you're diabetic, you tend to have depressed respiratory function, and she picked up this fungal infection. There are just not as many medicines for fungi as you might expect. So you go through all the medicines, nothing happens, one surgical option after the other, and you're inexorably going towards only one place, which was where she coded and she died. Which really, made us think, was it, while drugs were really super important, it was probably also really important to think about how one could prevent an infection from happening, especially when the person who would pick up the infection was someone who would be super vulnerable and could not be easily treated. That really was how we started this company called Biomoneta, where the idea was preventing the spread of infection. And we, for various reasons, decided to do it by building safe air products. So, a little bit of a longish background there, but, I thought it was sort of important to understand why we were doing what we were doing. So today, Biomoneta is an innovation-led healthcare company. We build safe air solutions. And the whole idea with our products is that how do you prevent the spread of infections, both in hospitals as well as anywhere where people might be sick. And we do this by building devices on top of our flagship technology. And this is the patented technology. And I want to talk to you about some aspects of IP around that as we go along. Oh, sorry. So again, since this was about 10 years since we started, it was sort of interesting to look to see if our mission had changed in any way at all. So I just pulled up a few slides that I had all the way back from 2014. These were not slides that were made for a presentation like this or anything. These were just thoughts that we were tossing around because we wanted to say this is the idea that we're working on. So we said, okay, you know what? There are so many nosocomial infections annually. More than 20 to 30% of people who go into an ICU die of an infection. And hospitals care about infection, but they're mostly looking to wipe surfaces, clean their hands. So what can we do that is different, right? And we said, medicine is moving along in leaps and bounds, but it's sort of supported by outdated air treatment. And what can we do different? And here we are 10 years later. And it's really interesting to see that the core need hasn't changed at all. Right? Airborne pathogens are probably the #1 health risk to the global population. We're coming off of a pandemic which caused over 7 million deaths. Today, almost a quarter of all infections in a hospital, surgical site infections, are because of transmission through air. And in India alone, you have more than 100 million people who have comorbidities like, diabetes or hypertension or kidney disease, which make you incredibly susceptible to all of these things. So time's moved on, but the basic mission has actually not moved at all, which of course begs the question, what has actually changed in 10 years and what did we achieve, right? So today, the people whom we hope benefit from our products are two kinds of people. One is not really people, it's really businesses like hospitals. And we believe by bringing in our intervention, you're actually able to improve both their economies as well as help, improve their reputation. But also from a patient perspective, you have people with, COPD, the elderly, you have neonates, and you have people undergoing chemotherapy who are all very, very vulnerable, to whom we believe our, devices will actually have value. And how do we do this? We do this by saying that, you know what, you're in a place like this, there are lots of people, so you're going to be surrounded by, germs of all kinds. There are some people who are very much more vulnerable. So best way to protect them is to make the environment sort of germ-free, and that's where we come in with our device. And we And the bubble is sort of just a nice way of representing, but the whole idea is you're creating an area which has low germ content, so to speak. And how does this actually work? I'm not going to take you through the technology, because the point of the whole business is actually not the technology at all. But to say, when you are a very small company in a not so small city in the world, but still a very small company, trying to build novel technology which is going to play in an environment which has been, what shall I say, colonized by a particular technology for a very, very long period of time, you have to do something that's really very different. And it can't be something very different from a technological point of view, but it has to be something very different from an effect point of view. So the background technology that I'm referring to, of course, is filters. I mean, we've had filters since the 1940s. They were discovered around the Manhattan Project. And, filters are ubiquitous of all kinds. And today, everybody believes that if you have a place where you have either a separate device or you have an air handling system with a filter in it, you are absolutely safe. But the problem is this. When it comes to actually how germs move, filters are really pretty ineffective of doing all of these things. Not just because they only trap and they don't kill, but you have different kinds of filters for different kinds of things, right? You have the kind of filters that you have that AHUs out here, which might handle, particles or germs up to a certain size. Then you're worried about things like viruses, which is what everybody was worried about during COVID. And suddenly you're talking about these tiny, tiny sub-nanometer micron particles, which need things like, ultra kind of filters, right? Which is the absolute extreme. But you can't take that and put it over here, because your electricity bill will mean that the university will basically cease to function altogether. So suddenly you're in a position where you don't have one solution for a wide variety of problems. And that's where we felt our USP was. We were able to build a technology that could handle every kind of germ that was equally, because we used a core fundamental biological property called the zeta potential. What it is, the actual tech, like I said, doesn't really matter. But it was important when we were a small company to find that one small differentiation, both from a technology as well as use perspective, which would allow us to compete with the established players, and would also allow us then to tell the established players, look, you are wherever you are. I'm really small, but I have this differentiator. And it's enough of a differentiator that I can give you an IP advantage. Can you now pick this up and transmit it to the rest of the world? So I think that's what we actually managed to do. As a part of doing that, of course, is a longish journey, which involves a reasonable amount of science and money going in. This is just a quick snapshot to show you, how our devices are actually tested. They're actually done in what are called sealed chambers or sealed test chambers, be various sizes. You take individual germs and you sort of aerosolize them, send them into the air. You start your device, and air with microbes enters the device, and then it starts getting destroyed. And over time, your room gets sterilized. What you see on the right-hand side is just making the same point I told you before, that using one device, one technology, we were able to handle every kind of germ that was there, starting from things like bacteria, which are important from a hospital setup, viruses, which of course from a pandemic sort of a setup, fungi. We started the story with the fact that somebody died of a fungal infection, and spores or fungal spores are disease-causing agents. So, really had best in the class effectiveness over this entire range of pathogens, so to speak. And it's not like we were the first folks out there who actually said we need to build technology that kills microorganisms really, really effectively, right? But if you look at everything else that's out there, most of it was sort of made for water or food purification, and usually ends up, it's a UV-based technology, usually will then release ozone. And so when you look at air it's not something that you just bring in, you do something and you go away, right? You keep it on forever and ever. So safety is a huge deal. So being able to have very, very high efficiency across a whole range of things and being super safe was the place that we were really able to compare with everybody else who was out there. But, again, some of the things you folks might have seen during COVID was when somebody talks about how good a technology is, especially for air sterilization or air treatment, they'll say, okay, it's about 99.97% effectiveness. No one really knows what it is. But it doesn't matter. There's a place where you go do a test and you get a number, and we also go get a number, and you say, okay, our number is better than your number. When you buy a car today and someone tells you this is my mileage, and they will tell you what a mileage is and it's under test conditions. But everybody has driven cars in, places like Jaipur, in the Golden Quadrilateral. You've driven it in the, the small off-roading that you do. And so you know how that one number, mileage number you get actually translates across. But nobody knows how a purification number that you get from a lab actually translates into the real world. I mean, nobody does it. And this was another place where we felt that we needed to differentiate ourselves. So we spent almost 2 years basically going to a whole range of places. I've just shown you a place from a hospital, but we've done that in meeting rooms, we've done that in pharma companies, we've done that in laboratories, every kind of place that you want to go to. And again, the details of the science are really not what is important out there. But the fact that because we took the trouble to go to all of these places, we were able to show, regardless of what the competitor device was, in the field that ours was able to perform significantly better. Move this one step further to take it to working ICUs, where we deployed devices for multiple months. And so, so at the end of all of this, this is just data that builds one on top of the other. And then you start asking the question, why do you need so much data, right? So you said you've built a differentiated technology. Surely that should be good enough. You got patent protection on that. Surely that should be good enough. But it turns out every time you bring something new in, the further you go along the value chain, the more your value also actually increases. And this also helped us sort of build on our strengths, which was not that we were able to, buy advertising time to say how ours was superior, but we were able to actually bring data into the picture and say that this is how we are really, really much better. And today, devices built with our technology are over 20 times more effective than any HEPA filter-based technology, which is coupled with, say, germicidal UV lights. It took us a really long time, right? Which goes back to the question that, we were discussing about pharma, or, how investment, say, someone from IT made an investment into BT and they withdrew really fast. But the fact of the matter is, if you are building new technology to impact healthcare, your journey is really, really, really long. And we started in 2014. It took us 2 years to actually build the team that could do all of this. It took us 2 years to bring funding in, because no VC firm will fund you for any of these things, which effectively means luckily there are enough schemes in the government which will give you a bit of a head start. We've been very lucky. We've gotten about 4 to 5 grants from both the central as well as the state governments. And it took us about another 2 to 3 years before we got that one unit that we were able to go and place in the hospital. But that unit was a really, really ugly looking thing. And so I just wanted to show you a few pictures of, things that we evolved around the journey. These are things that you will find in any lab, right? This is your garage model of things. And that's sort of the device right at the corner, which one of our users actually compared to, I don't know how many of you speak Tamil, but they called it a Tagara Dabba, which is effectively a tin box on a stand, right? But that tin box on the stand was actually able to do all of these things and get to a point where you could actually start thinking about patent protection. Because until we had all of this, we couldn't think about patent protection. I mean, all of us came from industries where patent protection was a pretty big deal. We all came from pharma backgrounds. But there was always this question of, how early do you file? There's a question of money, because how much money can you afford to spend on these patents? Where do you need to go? If you're a pharma company and you know where your drug is going to go, you know what geographies are important for you. But we didn't know what geographies were important for us. So in the beginning, the entire thought process was defensive, right? We don't want to find out 5 or 7 years down the line that somebody else has copied our product and then told us that you can't use it anymore because it's actually ours. So purely from a defensive standpoint, around the time when we started to work with the external world, right, with the hospitals, we started deploying over there, we filed our very first patent application. Did all the pretty standard things after that, went the PCT route. Definitely didn't have the money to go into multiple geographies. So picked like 2 or 3 geographies and said, this is where we will make the bulk of our money. And we will go, go and do the applications out there. But you also had to now commercially show that your tech was, worth it, that people are going to pay money for it. So we built our first few devices, took it to the market around the 2021 area, which is when we got our first institutional round of them. Again, these were sort of tin boxes too, the ones on the left-hand side, and they just effectively had only our own technology. Sold about a couple of hundred devices, made a decent amount of revenue for those devices. But people came back and said, you know what, I don't want a tin box in my home. I don't know how effective your device is. And then you're saying you're giving me safe air, but you're taking care of only one aspect of air. Because yes, and that's true. Because if you think of air and how you want to clean it, you've got to worry about particulate matter, you've got to worry about volatiles, and you've got to worry about germs. So we took a step back and decided to take the more open, innovative approach, if I might actually call it that. Picked up known technologies, which was the HEPA and the carbon, bundled with our own technology, found somebody else who made pretty exteriors, and put it all in together. And this is a version that now we actually retail. The one on the left is today retailed in Amazon, but because we have a healthcare, very strong healthcare focus, we have a different version that's going through FDA filings and so on and so forth. Today, hospital deployments alone, probably about 12 across India, but the studies keep going on. We talked about IP, and I think a lot of the conversation around IP originally was in terms of, filing a patent, right? But it turns out one way to sort of bolster your patent is actually increase the amount of knowledge you put out into the world. And the more number of studies you do in collaborative forms actually increase this amount of knowledge. And those in turn, it makes everybody know that you are actually the owner of the technology, where whatever the patent actually says or doesn't do. So based on our previous studies, we've had 2 or 3 publications, and now we are still expanding this to do, larger scale clinical trials with existing hospitals. We work with the government of Karnataka tuberculosis centers to deploy our devices over there. Some very, very quick, kind of feedback that we're getting from users right now, because it's not only hospitals, because individuals who are sick at home also use this. A large part of our users are people who have COPD, which effectively means they have breathing problems. And the first thing everybody says is that, okay, my breathing gets better, and if my breathing gets better, I sleep better. And if you can sleep better, you've effectively conquered the world. So that's sort of where we are. The other thing that kind of started when, we started off by saying we want to make a device for this particular purpose. We wanted to put it in a hospital and solve this problem. And then you build a technology. And suddenly that technology is effective in so many different places, right? If you have an air handling technology, you can put it in an AC, you can put it in an HVAC, you can put in a device which is separately outside. And one small company, we are 10 people, by the way, in Bangalore. There's no way we're going to do all of these things. And this is where that entire collaborative process of how do you now find market leaders who will pick up all of your knowledge, all of your technology, and go ahead. That's the stage we are in right now. We impact all of these areas with the same technology. We build multiple kinds of products, but mostly at the prototype stage. And then we go and speak to the bigger players, and we work with them to actually get products to market, which again is really possible only with a really, really strong IP strategy, because we've been 10 years out there without having a revenue as yet. Yes, we made some revenue previously, but that's peanuts compared to what's possible. And this again goes back to a discussion that's been having, that how do you actually build patent protection, right? We've also talked about building other kinds of knowledge. But you can have one technology and you can ring fence it with multiple patent applications or patent families around the same tech. So in the beginning, and this is almost entirely, unfortunately, a money question, right? So in 2018, we said, okay, we had money to do one thing. We had money to do one PCT application, and we had the money to go to 3 countries. And that's what we did. And for all of that, today we have grants. And it's because of these grants that we can actually have these conversations with these partners. But now that we have a little more funding, we've gone to our second family where we've gotten an India grant, and we've started doing the PCT applications and also in-country filings in a couple of key geographies. Couple more families of patents which are possible, but until you have the money, you're not going to be able to do anything with it, right? So there's a lot that one can say, but I want to just stop it here because of the theme of this particular meeting. And you can skin this cat any number of ways. But ultimately, for companies like us, the way you develop this strategy will be the question of whether you make it or break it in the long run. Thank you for listening. It was a very individualistic story. Sorry about that, but very happy to take questions.
this air purifier, whatever is there, whether they will be, how much space they can cover.
That depends entirely on the kind of fans they have. Every purifier is built with a particular fan and hence a coverage rating. But tech like this can also go back into HVACs, and there you're not dependent on a separate fan because you just piggyback onto existing blowers and so on.
Suppose in a 3-bedroom flat, something like that, maybe area around 2,500 square feet.
It's not about the total area because there are rooms, there are walls separating it. So you probably need any device per room, one device.
Oh, okay. So you can, who is manufacturing actually these things?
We do very small scale manufacturing only to prove that this thing does what it's supposed to do. Ultimately, all of the manufacturing will be done by our partners who will pick up the tech and actually take it to scale.
You need a tie-up with any big manufacturer, or you want to go alone?
We definitely do not want to go alone. I mean, that was the whole point of what we did everywhere, right? We said we'll build something really strong. We'll protect everything really well. And we will do enough to show people that this does what it's supposed to do.
Yeah.
But we can't do it ourselves because, I mean, as a startup, how many will you sell? A few hundred, a few thousand? But whereas you're talking about lakhs and tens of millions of devices to go all over the world. So you have to go with partners on this.
So if you are you interested in, suppose a financial tie-up is made with some manufacturer of this kind, will you be interested? In the sense, your company will be interested in
we're
sharing that?
We're open to all conversations. Yeah. We never close conversations down. So very happy to take a conversation.
Because I bring mega projects to Telangana.
Understood.
And also Andhra.
Okay.
So I brought around 6,000 to 7,000 crores worth of projects. I'm a High Court advocate.
Got it.
And I'm doing this regulatory work as well as setting up of mega projects in both the states. So in that context, because this HSIL, Hindustan Sanitary Industries Limited, he is my client.
Understood.
So they are also manufacturing air purifiers, but not on major this thing. But because these things are having major advantages of this, they are having big market for that. So that they are manufacturers, they can also have tie-up with these things. They can do a lot.
Very happy to have a conversation, sir.
That's what I want.
Sorry? So our facility is 13485 certified. Oh, I see. We can go up to a 6 or a 7.
Okay, 6 or 7 means 100,000.
100,000, one step below that.
Otherwise, this is very much useful for the farm industry because we can replace to the clean area.
Indeed.
That's very, very costly.
Indeed. So it's very interesting because one of our very first users was actually the Stem Cell Research Institute in Bangalore, which wanted to build a tissue culture facility, but they didn't want to, spend that X amount of lakhs to actually set something like this up. One device goes in and you have that little area. So yeah.
Before proceeding to ISO certificate is required for the grade.
It is. It is.
Madam, how your device is used for? Madam, I'm Srinivas.
Please.
We'd like to know how your device is useful for Delhi. Delhi air quality index is falling down very rapidly.
We will not be any different from any other regular air purifier in that context.
And whether this device, whatever device you have developed,
correct. So the things that we retail and Amazon put all the technologies together. So we also have a HEPA filter in there. So it works on pollutants and everything. But you can get a 6,000, 7,000 rupee air purifier if you're worried only about particulate matter. So,
Madam, whether this device developed by you, whether it can be fixed along with a ceiling fan and the air vents, air conditioning vents.
Yeah, HVAC it can be fitted on. That's it.
Whether your devices are tested in Delhi, madam?
Yes, they are.
Is it encouraging? The results are encouraging?
Yes, they are. They certainly have done very well over there. They compare, in terms of particulate matter, they compare with anything else that's out there, and compare with germs, of course, there's no comparison. So,
now, how do we prevent that kind of situation in other cities of the country?
I don't think single technologies like this can do it. That's probably a much larger problem. I'm sure that'd be a great situation for discussion separately. If you don't mind, we have a gentleman.
Happy to hear a story. Happy to hear a story.
Thank you.
Very nice. This my question was what IP skill data, right? Do anybody infringe your IP? And what you have done if it is so?
The point of infringement actually comes at a slightly later stage. You need to be at a certain volume before people will bother infringing on you, quite frankly. And our job is to make sure we ring fence things enough so when we get to that stage, we have a way to protect ourselves.
That's fine. Thank you.
Sorry, the lady in front.
Particle matter in they will be having different sections like A grade area, B grade area, C grade area, like that. So how you define with only one equipment? I mean, you are more focused on infections control, but you didn't explain about the particle matter count and all. So that's want to know. And how cost effective it will be for different sections.
Sure. Let's come to the cost later, but your question is a very valid question. And the point is, I've talked to you really about a technology. Now, the technology in different application forms, the different product forms, find uses in many different ways. We've spent most of the time with hospitals and patients because, well, that's where our core focus was. But at the same time, when we've gone to places like, biology labs or pharma, again, it turns out that one solution doesn't fit a whole bunch of things, right? So if you want regulated areas, you want regulated products for that. You don't want new products at all. But if you're looking at mixed use areas, or if you're looking at places where you don't want to spend that 20 or 30 lakhs to get something going, but you want to quickly test something out before you spend the money, that's where products like this come in that kind of a context. So we've had institutional labs, right? University labs, instead of doing a GLP level thing for tissue culture, they have used this. But that's not a regulated facility, you see.
To what extent is it affordable?
I don't want to talk about affordability right now because we make 50, 20, 30 units at a size. When we're selling on Amazon, that's selling for 20,000, which I don't believe is very large. But that's what we're doing right now, but we're still not at scale.
Ma'am, this question might be a little bit funny. So you have to answer this question to my father actually. Before that, it was really wonderful journey, ma'am, the product that you have designed and the obstacles that you have faced. So my father always used to say, Sharachandra, please don't use all this filterings or ACs or water purifiers so that your body will stop fighting with the foreign particles. So he never allowed me to purchase all this kinds of stuff. If we are using your product in the household, so what would you suggest to my father if I want to purchase this as a product?
Okay. In the first place, everything is about positioning. Now, can I ask you, in your family, do you have somebody who's struggling to recover from surgery? Do you have somebody who's...
A small correction. I'm talking about household, not in the hospitals.
Yes, no, we're talking about patients at home as well. But the point is, we do not market this to all and sundry. This is actually marketed as an air sterilizer, which effectively means you're really focusing on people who would be significantly affected by something like that. Right? If you're a perfectly normal individual, I mean, if you look at it that way, my mother didn't even like us to put on fans in the house. But today you want to live in air conditioning all the time, right? So it's need, entirely based on need.
The question why I asked, we are the product builder, so we want to give justification to that kind of generations also, where they don't allow us to purchase and put that things.
But the point is, it's not a generational thing; it is a need thing. And that's where the product market fit comes from, right? You're building a product, you're never building a product for everybody. You're building a product for a particular use. And if you are a healthy, happy individual, you shouldn't even have a fan in the house.
Thank you so much, ma'am.
Thank you so much for your time, everyone.
In my family also, nobody is suffering from chronic ailment. I have one of those devices at my house, and
Sorry to interrupt.
No,
I
no,
should
no.
say he's our IT advisor. He's sort of bound by one of us.
Okay. And bound to buy, I have still not paid for it. Okay. What was alarming to me is not, see, I know the technology, I know inside the details of the product. What was alarming to me is that when this device appeared to my house, I just switched it on. There's a meter there. It tells you the particle density. The See, it's considered that below 25 is almost safe. That's what science teaches us. The initial reading was shocking to me. And I thought my house was quite safe and clean. And we employ people to do that on a regular basis. It was over 156 or something like that. And I just wanted to check the effectiveness myself also, although I've seen it in the lab earlier. In about 25 minutes, it came below 20. The point I'm trying to make is here that I did not realize, I did not understand that um, the normal counts are so high around us. And we are immune to it. We don't need it. That's also true. But if you're somebody suffering from chronic ailments, it does benefit. And I've seen umpteen cases that it has really helped their quality of life. It doesn't help the treatment. It doesn't cure you, but it improves your quality of life.
Thank you, ma'am, for your presentation. Now we call on sir to give mementos to everybody that spoke in the morning session before we break for lunch. Welcome back, everyone. We hope you enjoyed your lunch. To kick off the afternoon session, we have Mr. Ravi Bhola, Managing Partner of KSN Partners. He's a biotechnologist and a lawyer. His focus areas are patents and designs. He's also a certified patent evaluation analyst and enjoys working with exciting startups as well as mentoring a few of them. On the policy side, he is the General Secretary of the Association of Biotechnology LED Enterprises. In addition, he is a member of the IPR committees of FICCI and CII. He also provides pro bono support to a few social organizations, including the Spastic Society of Karnataka. And he has requested me to keep his introductions short. So, sir, take the stage.
Hi, good afternoon. Just you had sumptuous lunch, right? I also had sumptuous lunch. So the challenge is for you and for me to stay awake during the session. All right, you have to help me stay awake. So first of all, a big thank you to Dr. Ananda for having me here, and also to NALSAR. I'm delighted to be here in the campus, beautiful campus. What I'm going to do over the next 35 to 40 minutes is to share my own experiences, having worked with and represented almost 200 or so startups in different areas of technology. So while my educational background has been more around biotech, but then working in a law firm environment, sometimes you dabble with different kinds of technologies. So kind of work with different kind of startups in different domains. And I'll, in this session, talk about some 7-8 key learnings I have had and advice which I gave to generally to startups, but a lot of that would hold good even for mid-size and large-size companies. All right. I've been told that the audience here is very interactive. So what I'll try to do is to run through the slides. I have 45 minutes, 45 minutes. So I'll read through slides in about 30 minutes or so, and we'll try to keep about 10-15 minutes at least for conversation. All right. About my firm quickly. I represent KNS, arguably the largest IP firm in the country today. Pan-India, spread across 7 cities. We just opened Pune office this month, and a team of about 375 people handle end-to-end IP, everything within IP, nothing beyond IP. All right. So we talk about startups. Let's look at how startups are defined in India. So any organization which was set up in last 10 years, at no point in time in its existence, it had a revenue of more than 100 crore in a year, focused on R&D, and is not a spin-off or a part of a large size corporation. That's how, under the Indian system, the law defines startups. All right. Now, before I get into specifics of what has happened in India, especially in last 7-8 years, so when many of us started our practice, 20-25 years ago, the challenge with the IP administration and system used to be that used to take forever to get IP registered. Even the domains where you could get, IP registered, like patents registered, were very, very small domains. In many domains, we heard about some pharma space, in the previous session. So a lot of pharmaceutical inventions were not patentable. Even now there are regulations, but it was much worse earlier. And as I said, it used to take forever to get IP registered. Everything was manual. And since there was not enough push from the government, also the other stakeholders like law firms and innovators also were not really pushed to up their game. But last 7-8 years, what we've seen is the IP administration in the country has improved significantly. Trigger was at the Patent Office and Trademark Registry in India to say, hey, we need more people because there's a lot of backlog. It's taking 7, 8, 10 years to get patents granted. A lot of it is manual, so there's not enough transparency in the system and not enough accountability, both for the Patent Office and for law firms and also for innovators. So a lot of digitalization in last 7-8 years. They ramped up IP teams at the Patent Office, and now today as we speak, the amount of time it takes to get IP registered in India, and especially for startups, is generally under 1 year from the time you file request for examination. And even otherwise, generally it takes about 3-4 years to get patent registered in India. And trust me, I closely look at how it works in US and Europe and other parts of the world. This is comparable to what you see in terms of timelines with some of the best jurisdictions in the world on IP. All right. US today takes 3 to 4 years. Europe takes that much time. Japan and China also take that much time. And by the way, for startups, what India has been able to accomplish is honestly absolutely extraordinary. When they launched this program for startups, we thought it's not going to fly. But what we've seen last 4-5 years is that they've been able to consistently deliver on this. So many of the startups that we represent have been able to get patents in like 7-8 months, which is great. Now, what we've also seen is that one is you get IP registered. Why do you get IP registered? Ultimately, you want to enjoy monopoly. You want to create barrier in your industry so that your competitors are not able to catch up with you. You expand your market share. You want to kill the competition, have the monopoly, right? Now, how do you enforce it? One is to get patent registered. Second is that tomorrow, if something goes wrong, if you want to sue someone who is copying your technology, or if, let's say, God forbid, you've been sued by a competitor, the judiciary also has to support you, right? So now what has happened, especially in last 3 years in India, is that the specialized IP courts have been created. The first one to do that was Delhi High Court, which is the busiest high court for IP matters in the country. 70% of IP disputes are handled by Delhi High Court. And that High Court, about 18 months ago, started the specialized IP court, what they call as IP division, and it's working quite well. Looking at the success of that, Madras High Court started IP division just 3-4 months ago. And as we speak, Kolkata High Court is in the process to set up specialized IP courts. And soon you will see the same thing in Bombay High Court. Now, what do these courts do? One, their mandate is to only adjudicate IP litigation, right? Because earlier the challenge used to be judiciary would say, hey, I mean, I've got all kinds of cases, right? I listen to the murder case. Next minute, I hear a bribery case. Then your next case is a very complex patent technology. Judges also had a bit of a challenge. Many judges used to shy away from looking into IP, especially patent cases. Trademark, they were still quite comfortable with. But now with specialized IP courts, we have judges who already have some body of experience in IP cases. So what courts in India are doing today are to build both capacity and capability in the judiciary to able to handle IP disputes. Early days, things can go wrong, but whatever we have seen in last 18-20 months is a game changer in my view, right? And that is how IP is supported, not only by way of getting patents in your pocket, but to be able to leverage it if push comes to shove. All right. Now, so a lot has happened in that sense, but we still have a long way to go. Now, basis that, I have few pointers I wanted to share with you. When I work with startups and we work with founders, the biggest challenge that the founders have is that they have a lot going on, right? If you're a founder or a startup, you want to make sure that you have enough capital, right? You're able to raise funds. We just now heard, Dr. Janani from Biomoneta. It's not easy to raise capital, right? So founders are struggling to raise capital, build a team from scratch, have a product out, and then make some money. In the midst of all this maddening rush, they also have to find a way and find time to protect their IP. They know they are creating IP. Every day when they have conversation with fellow colleagues, they are creating some sort of IP or the other. May not be a breakthrough idea every day, but every day the small improvement, innovation contributes is an IP. Some of that you may want to keep it as confidential, but it's still an IP. The challenge for founders and startups is that how do you take out time and be able to protect or monopolize what you're developing literally on daily basis. And that's where founders struggle. And our generally the advice to founders is been that while of course, yes, a lot is going on, you don't want to be in a situation that you have a perfect product out and then somebody will just copy it. All your hard work will go for a toss. All your money that you put in on R&D will go for a toss. Because the moment you have something which is interesting, somebody in the market will just look at it and say, hey, I like it, and they'll go ahead and copy, unless you're able to create a barrier. It's important. And therefore, the advice to the founders always been that if you are short of bandwidth internally, ideally your CTO or technology guy should drive this, supported by maybe legal guy, internal or external. But you need to find ways to map what you're developing. Not everything need to go for IP registration. Most of the things probably need not go for registration per se, but you have to find a way to say, hey, I've developed maybe something which is a trade secret, confidential, something which will qualify for design registration, maybe not for patent, but how do you bucket them? How do you identify them? How do you map them? And then based on your priority, based on the budget, based on your capital, you take a call which one to pursue, which one to let go, and how and when. So that's an important piece that is important for young companies. A lot of it, as I said, would hold good even for mid-size and large-size companies, but particularly relevant for young companies, because by the time you reach a scale, you're able to establish some processes and systems. Your legal team is there, your in-house tech team is big enough that somebody can handhold and drive this. Something that is very important. And lastly, when you approach investors, they would say, why should I put money in you? Because what you've developed is something that another player can easily make, unless you have created a barrier, right? So even investors for whom you're actually making a nice product so that you get capital, you scale, even they won't be serious or interested in your technology unless you're able to create some barrier by way of IP, patents, and other forms. The second thing, which often we see happens with young companies, is that, let's say you're working in an incubator. I've been told that there are some folks from incubators here, and you're working, let's say, in an academic setting. You're incubating young companies in your incubator. You will have professors coming in. You will have consultants, contractors, interns coming in. You're using bandwidth because you want to leverage the knowledge of a professor, and you also want to have some sort of a bandwidth support from interns, short-term interns. We all do it when we're young as a company. But then who owns the IP? Do you have enough clarity whether the professor in that university that you brainstorm with, if tomorrow an IP is created, a new piece of tech comes out of those conversations, is it that university? Is that you as a startup? Is it joint? Have you looked at what the IP policy of the university says? Is your contract with the professor or with interns or with PhD scholars who might work with you, is it in conflict with your NDA with them? So that kind of a understanding, clarity, alignment is very, very important. You can't be in a situation where you presume you own it, you put in your capital time, and when results start looking exciting, many people come in and say, hey, I also own it, or we co-own it. You don't want those surprises. So just make sure that you have enough clarity on who owns that IP. And it's important to have that clarity upfront. Some of these conversations may look awkward, but I think it's important when you are putting so much time and effort to have a startup, have that clarity upfront. So that's second piece that I thought is important for us to keep in mind as a young company, particularly. Another piece is that not everyone who works on a technology in your company is an inventor of that piece of technology or the patent that may emerge out of it. You will have, let's say, 5 people on a project. 2 have given great ideas. Remaining 3 have merely executed the ideas of other 2 people. And the execution was pretty straightforward. No surprises, no ambiguity. Desired results were obtained. Who would be the inventor for the patent which may get filed ultimately for that invention? Generally speaking, it should be those 2 people, right? Sometimes the dynamics may play out in the lab where you may want to name all 5, right? You want to be nice to an entire team, keep the team, galvanized and motivated. But I think it's important for us to have that clarity who would qualify in terms of contribution to become an inventor. Be aware, in some countries in the world, by way of law, every inventor is eligible for certain profits that the company might make out of that product. For example, in Germany. So be mindful. And I'm not saying that anyone who qualifies should not be mentioned as inventor. All I'm saying is be mindful there is a correct kind of inventorship identified in the patents. In certain countries, the law is that if your inventorship is not clearly identified, the patent itself can go for a toss during examination at the patent office. So be very mindful of this part. Okay. Now, next piece is about this. The whole deal about patents is that you disclose what you have developed. In lieu of that disclosure, the government will give you monopoly, right? Monopoly for 20 years. Very powerful right, because you're excluding everyone else in that country from practicing that piece of technology. Very powerful right. But how do patent office know? How will they know that you're actually in possession of that invention? Your claims could be very broad in that patent. You can claim the entire world, but how will patent office get the confidence that you're actually in possession of the invention? You are the developer of the invention. They'll get that confidence. One, of course, they'll do prior art search to ascertain your invention is novel and inventive or not. Another piece where they look at is that degree of disclosure you have made. What kind of experiments you have disclosed in your patent specification to prove that you have developed that invention, you have that invention in your lab. So idea, simple first impression could be, hey, then disclose as much as you can, right? And get the patent quickly. But then if you dig deeper, you will realize that you require certain degree of disclosure to get that monopoly. You disclose less than that, you're finished because your patent application will be rejected by the patent office. You disclose more than what is required, you're letting everyone, including all your competitors, know what all exactly you're doing in the lab. So striking the balance is critical. And it's always a moving target because law also keeps evolving. And that's where sometimes, taking professional help can really strengthen your case, but make sure you don't overindulge by disclosing too much in the patent, because a lot of what you have in the lab could qualify as a trade secret. Why do you want to disclose it to the whole world? That's your competitive advantage over and above patent. So keep some of it to yourself, disclose information to the extent required to get you a meaningful patent, and stop at that. All right. It's not easy to strike that balance, but it's imperative to have that balance if you want to have strategic advantage over your competitors. For example, I know I run an experiment or a process in the lab. I know the workable range, let's say for temperature, is 20 to 30 degrees centigrade. I put that broad claim, but I know 24 degrees is the one where it works the best. Should I disclose it? Should I not? That's the kind of conversation we need to have. Why do you want to make life easy for your competitors? So strike that balance. That's the point I'm trying to make. Next piece is around seeking multiple layers of protection for a piece of technology or a product that you may have. Just think of it, simple thing like I have, let's say, this pen I have created. I'm the inventor of this pen. And the technology essentially, I have this technology where it's an ink flow technology where it works very well in a certain way. Ink lasts forever, whatever you want to talk about. Let's say I've developed a crazy technology. Now I will seek patent for it, the technology. So patent is the right tool, let's say, to get the monopoly for that. Patent is one. Then I would say, hey, it's designed very nicely, right? It looks good. I should also get a design registration for the pen just for the appeal to the eye, nothing to do with the functionality. That becomes my design monopoly. So one was patent for technology, the way it works. Patent is independent of look and feel. I can change the color, I can do whatever. I have a monopoly over technology. That's a strong right. I supplement that by design patent to say, hey, this is the design with which I launch this pen in the market. So I'll get a monopoly for this kind of a design. Even for some other variants of the same design that I may launch in the market, I'll get design registration for it. I write a beautiful piece of, I write a fictional story using this pen. What have I created? When I write a piece of paper, let's say scientific paper is what I have created. Can I have an IP over that document? Would be copyright, right? So that's a copyright registration I can have. So the point I'm trying to make is that a single product, multiple layers or levels of IP. So be mindful of that. How does it help? Because let's say, just think of it, and this is an actual example. So one of our clients, a large size company, filed for a patent for a medical device, also filed for a design registration. Patent for a large company, typically in India, would take 3 to 4 years. Design probably 6 to 8 months, as I mentioned in one of the earlier slides. Now, this client of ours noticed that somebody is copying their product, medical device. Now, I cannot enforce a right unless I have a registration with me, right? When it's pending, I can't leverage that right in terms of enforcement because my application is still not being tested by the granting authority. So I have no right in that sense for enforceability of a pending IP application, patent or design. In this case, while patent would take 3 years or 4 years to mature into a proper granted patent, my design application got granted in 6-8 months. And I could immediately leverage that design to go after the competitor to kill that competitor, right? So having multiple layers helps you in different ways, sometimes in very unexpected ways also. The idea is that if you have the budget and if the product is really of importance to you, consider a multi-layer protection to the extent that product or a technology can qualify for. It strengthens your case. We often give a classic example of, Gillettes, this multi-blade razor and all that stuff. There's a typical example that are used where for simple razor, they got dozens and dozens of patents. What they call as a patent thicket. They make it so hard for a competitor to be in that space. They enjoy massive monopoly in the market, right? So use different tactics and strategies to be a market leader and kill the competition. So keep the options open to seek multiple layer of protection for your IP. This is again something that Dr. Janani talked about. Young company, limited capital. Should I start only with India? I'm based in India. Because patent rights and IP rights largely are all territorial rights, right? So I have a patent in India, it's enforceable only in India. My monopoly is restricted to that country. So startups and young companies always have that challenge that may not have enough visibility. Which all countries tomorrow they can try to be in, right? Little bit of it is guesswork, little bit of it is your strategy, but you might never really know. But to totally ignore the option to cover other jurisdictions based on where you anticipate you might be is important. Also, in most of the cases for IP, there are some timelines, there are statutory deadlines within which you have to enter into other countries from the time you, let's say, file for your patent or design, let's say in India, if you are based in India. So there are timelines attached to it. So be mindful, one, to make sure that you are able to protect at least those countries which you believe are something that will enter into in foreseeable future. And often engaging with investors help. If you have somebody as a existing investor or someone that you see as a prospective investor, even a conversation with prospective investors can come in handy. Because sometimes it's good to brainstorm with people who might be willing to put their money on your startup to say, hey, where do you anticipate these products to hit in the market? Because once you miss the bus, in most cases, then you miss it forever. And we have seen cases where some products have done extremely well in India, but by the time the founders have the resources and bandwidth to think about jurisdictions beyond India, it was too late. And then the competitors could literally copy that product and had a free run in US, which was 10 times the market that India was. So just be mindful. I know it's hard, it's not easy, but just be aware of those scenarios and act accordingly. Other piece is something that I think doesn't get discussed often, but is important, especially when you are, planning to hit the market with your product, to launch the product. So just think of it. We were discussing it, in one of the previous panels, when the presentations were on. before lunch. Let's say think of it. We say Apple has got a fantastic technology and the mobile, right? Most of us love Apple, iPhone and stuff like that. The question is that can Apple or is Apple able to just make the phone and sell it in the market? Is everything sitting in that device proprietary item of Apple? No. There are dozens and dozens, probably hundreds and maybe to some extent, maybe even thousands of patents that might be sitting in that one device. Not all those patents are owned by Apple. So let's say if they have a chip, the chip design, let's say, comes in from Qualcomm, right? So in that case, can Apple sell its iPhone without getting a license from Qualcomm? No, right? So essentially what we're saying is that when you, let's say, develop a formulation, a pharmaceutical composition you develop, it has got 3 components. If one of them is somebody else's proprietary item, somebody else's patent, well, you can get a patent for formulation A plus B plus C, but you cannot commercialize your own patent because one of the is somebody else's patent, which means you have to take a license. If that is the case, in some cases you'll say, hey, A is been wrongly granted a patent. So you as a formulation guy, theoretically you also have an option to go after the one who has A and kill that patent. Then you don't need to worry about license as a possibility. Or you can have a scenario to say, hey, I know there's a patent for A. I know it's a invalid patent. Right now, I don't want to invest my time and energy to invalidate that A. I'll go ahead and launch my product. If they come to me or come after me, I'll probably handle it at that point in time. Different tactics for different companies based on scenarios. But be mindful that especially when you are about to launch the product or you believe that what you have is not only patentable but can tomorrow be in the market, that's the right time for you to get an FTO analysis done, which means that it will help you figure out in your country or countries of commercial interest to you, which all patent exists, which can hurt you going forward. And then you appropriately design your strategy to deal with that scenario. All right. That's important because, and I'm not advising you to do this for every project that you run. Do it for the ones which you believe are promising and tomorrow you may have some sort of a commercial activity around that technology or product. I think this is the last slide I have. And this is about the size of the IP portfolio. When you, let's say, as a young company, you get some capital or you want to raise capital and investors love large size IP portfolio, you tend to you run the risk of sometimes building a very large IP portfolio. All right. Well, I'm not advising you not to do that, but what is also important to keep in mind is that focus on quality, because ultimately if you have 5 good patents, strong patents, it could be far more powerful than 100 patents. I know in the journey of any company, often you will see the focus initially is on numbers, on volume, because it's all learning as you grow. But I think as a young company, especially when you're scarce of resources, be mindful that once you develop that understanding of what IP is really valuable in terms of registration and what all can still be kept as a trade secret or confidential information, strike that balance. So while you need to, as a young company, still have a critical mass to be visible in the market, because you started off claiming or building IP portfolio, one, to have monopoly, also maybe to create a little bit of a fear in the competitor's mind, also to be able to attract investment from investors. But after a point, don't make it just a number game. Focus on quality of IP that you have, that will fetch you good returns in every possible sense. You also have to remember that once you get the IP registered, you have to maintain that IP. It's like paying your property tax every year. You pay for your house and commercial assets. For IP also, generally, especially for patents, you have to pay property tax every year. So just be mindful how much, what is the size of portfolio you can build. And this is interesting also in terms of the conversation that took place, before lunch. Often in telecom and IT space, you will see companies going for large number of IPs, large number of registrations for patents particularly. In pharma, it's much lesser, probably 1/10, I would say. And that is just because the nature of animal. In technology space, the innovation cycle is much shorter. In pharma, once you start something in the lab, if you're lucky, if you're very, very lucky, the product might hit the market after 10, 12 years, right? So game is different. So be mindful of that. If in pharma, your quantum could be very different from what you have in the telecom or IT space. But just overall, keep in mind that you don't end up building a big IP portfolio, which is not meaningful. It'll be just like a white elephant. You'll just keep paying property tax on that. So this is what I had. I don't know whether I'm still left with any time or not. If yes, probably we can take up a few questions. Otherwise, I'll stop here. Yeah. Don't ask difficult questions. I've been told in the first half a lot of difficult questions were asked.
I'll ask a very simple question. Now, see, it was a wonderful presentation, very, very systematic, very, very organized. Now, you have mentioned one point that we should, even doesn't matter the size of your portfolio. Okay, now there are times where the value of the portfolio changes because the value of individual patents changes. So it's a good idea to revisit them at a fixed time interval or at some interval. That's what the question is. Revisiting your portfolio, can you suggest some, checklist points that one is into that would help the startups to, trim their and control cost to a large extent? So, can you set some checklists?
Yeah. So that's a great point you raised, Dr. Nindya. So a lot of IP mature organizations do a regular IP audit. Some do it annually, some do it once in 2 years, but largely they do look at the portfolio for different reasons. But of course, to, let's say, stay as a market leader, and things like that. Also to, just manage their cost better, in terms of budgeting and all of that. Now, for some of the players that we have kind of, looked at this as an IP audit exercise, I think one important thing that often plays on the minds of these people is that, is this a piece of technology IP that I would still have interest in mid to long term? For the near term, it's pretty straightforward. That's straightforward. But I think that often I see that these companies are looking at whether even to mid to long term, this IP will get used internally or not. If the answer is no, largely no, then they would say, can I license it out and make some money out of it, other than just keeping it as an asset and not yielding anything? Or they would say, I don't think there'll be any interest in the market. I'll just stop paying tax or whatever, annuities, and let it go. So that's monetary consideration is one, because they will say, I have limited budget for this year and the focus is on new technologies. So today, for example, and I think it came up in the first session also, is that a lot of companies are now pivoting towards, let's say, AI or generative AI. And they're saying some of the technologies that they thought they will use, this is now in view of, how the world has pivoted. Those other technologies will not get their attention for next 5, 7, 8 years. They're clear now because of the evolving situation, like you talked about. Sometimes how the market has shifted, how the world has shifted, leads to, shifting in my own priorities as a company. And then say, I'll let go because whatever resources I have, manpower I have, I want to put all my energy in a certain direction because that's important for me today, which was not the case in the past. So it could be mix of those things. I mean, when a lot of tech companies, especially when you see when they downsize big time, you hear about Microsoft, shutting down some of their businesses around mobility or stuff like that. Then, sometimes the portfolio around that also get either truncated or kind of disposed of in different forms of shapes, be it licensed out or just donated to public, so to say. So I think that there are different elements. There are a lot of other elements that also come into play, but these 3-4 are the major elements which plays on the minds of the companies when they do this kind of IP audit. Yeah.
I've got an unpopular question for lawyers there. So, what scope of automation, registration, and implementation strategies? I mean, of course, it's a no-brainer. You still need lawyers to process through a lot of innovation, and then even file applications. But then there is still a lot of scope, right, in terms of strategy, in terms of implementation.
No, it's not a difficult question. It's a fun question. I always say that lawyers always find a way to survive and thrive. All right. Now, I think, what I believe, I think holds good for every industry, not limiting to legal industry, is that people who are AI or generative AI, they always will evolve, upskill, and find newer opportunities, and new roles will come up, new jobs will come up. So, for example, on a lighter note, now today, if you do Google and say, one of the important skills that are required in today's world is prompt engineering. So all the engineers are now learning how to input the right kind of question into Chat GPT to get the right kind of an answer.
Even lawyers, right?
Lawyers, of course. So I'll tell you, interestingly, and it's fascinating because I spend a lot of time on this and have conversations with people across the world. So, when for example, when Watson came in from IBM, that's 10-year-old story, more than that probably. But that time itself, at least the top-notch US law firms had said, I don't need first-year associate in a law firm. Because all that the first-year associates used to do was legal research to identify relevant case laws and put a small summary around it. So I know at least half a dozen US law firms, they said, I will let go of all those associates. But then what happens is those associates realize they have to up their game to stay relevant. So that's how everyone moves up the value chain. When in early 1900s, when the automation started, people said factories will come to an end, right? But everyone moved up the value chain. Now in the legal industry, just to now answer your question, the trends we are seeing are the following. In corporate commercial practices, in litigation practices, a quick identification of relevant case laws has become easier. Quick creation of or identification of preposition of law has become easier through these tools. Creating summaries have become easier through these tools. But then you also know that these are the tools where when you create or get a summary, let's say from a Chat GPT or a similar tool, it also has hallucination as an issue, right? And also it doesn't have the emotions. And we are all about relationship. So it has maybe a lot of brain, but has no heart. Now, a lot of what you'll develop as a lawyer would be a lot of customization, a lot of case specificity that will come in. But then in certain kinds of work, these tools are being used to create a first cut. For example, in patents, now we have a challenge because if you input, Chat GPT, the invention, you're finished. You're finished. So in patents, for example, it right now may have a limited application. For example, some law firms I know in Europe use that tool to create a 2 paragraphs, what you call background of the invention. In patent specification, there's a section, background. They use these tools to create background of the invention. Now, how it is also helping is that while ChatGPT is open AI, open platform, what you can do actually, it's very interesting. What you can do is you can create a closed loop transformer, LLM, which means let's say you pick up one of the basic LLMs from IBM or whatever, you take a license, you teach it by inputting, let's say, your own law firm's documents, the body of work you have created as a law firm on certain issue. You input 2000 documents into that loop transformer. It learns something in the process. It's not open to public. It's all private transformer. And then it is ready for you as a generative AI. Now here also there are pros and cons. I won't get into that right now. But then I think law firms and communities in general are finding ways to make it more like collaboration than a competition. So that's how it's evolving. Early days, but I think interesting times.
Yeah, I've just asked an open-ended question. Let me be more specific now. This is more relevant to everybody in the room as well.
Yeah.
So it's still an absolute pain in the backside, the whole implementation strategy and also the enforcement. Oh, IP. Let's say the patent. You've at least heard 5 different stakeholders mention that it's taking so long and things like that. Around that, that is ultimately the elephant in the room, right? In terms of infrastructure.
No, yes and no. Yes and no, because it looks, it depends on how you look at it. If you have seen the journey of last 25 years that some of us have seen, you will see a lot of positives. So a lot depends upon what's the window period at which you're looking at. So I have been, and Ananda sir much before me, we have seen days when the patent term for certain kind of inventions used to be 7 years, not 20 years. And you used to get the patent granted in the 8th or 9th year. Term is gone. After that, I'm getting patent. So if you see from those days to today, when for startups in 7 months, you get the patent.
6 months.
6 months. So it's relative. But I agree that let's say especially in pharma space, so telecom is different, IT is different, because you're seeing less third-party interventions in currently in patent office in mechanical, software, high-tech space. In pharma, you see a lot of third-party interventions because we're sitting in Hyderabad, strong generic pharma industry. When you have third-party interventions, you have to have, there'll be, cross-examination, whatever process, not cross-examination, but it'll run through a proper process of pre-grant opposition, post-grant opposition, and there also mechanism is sometimes abused. I agree. It's that sector which I think needs to be reformed big time, fully with you on that. So a lot depends upon how you look at it. I mean, today, there's so much of, we used to have challenge when we used to have reach out to examiners and reach out in person and beg for time. I remember my first hearing, sir. I don't know how much time we have, but my first hearing at the patent office, there was a rack, physical rack where files were kept. I showed up and I was told, Ravi, if you can find your file, we'll have the hearing today. From those days, today every hearing happens online, on time, and there's an accountability within how much time the examiner will issue a final order. So as I said, it's relative. But yes, it may not be applicable for every case, but I think directionally, I feel we are heading in the right direction. And I've been historically very critical of, I studied in JNU, so over the lunch we were discussing, I'm an activist, all right? But even an activist and a JNUite like me can endorse that directionally we are heading in the right direction. Yeah.
Massive change.
Massive change. We didn't see it coming, honestly.
7 to 8 years was normal. Now 7 to 8 months is normal.
Yeah.
See, the act also has procedures. Okay, you are asking from an open ground. which allows certain timelines to pass for the next action to initiate.
Yeah.
There's a request for examination. There is a ground that see you can't really have it less than 6 months because you have to allow time for opposition. 6 month timer is there for opposition. So how can you get a patent before 6 months? So these things have improved a lot, and I think it is getting optimized.
Yeah.
See, certain things take time because the systems are built like that. So you can't see, for example, you cannot become restless and say that it should be less than 9 months. It can't be. That's how the system in all humans are built. So being restless, being critical will not help.
Yeah. Yeah. In fact, now, the conversation is honestly in the community that we have accomplished quite a bit on speed side of things. We want the conversation now to pivot towards qualitative side of the examination. We are saying, look, you fixed the whole thing around timelines. Now we want better examination because we want our IP and patents to be valued more in the global community. Why a European patent today is seen more valuable in certain ways? Because it goes through certain rigor. We have to, that's one area where we have to make a progress. Areas like where, how did we improve the speed? By getting more examiners onboarded? They're young guys. So they need to get trained, bring in more consistency. That's another area where we have to make progress. There are, of course, newer challenges in view of newer environment that we are in. But, as a I'll tell you real example. So some of my US clients, for whom I've been servicing for 20 years plus, and they're some of the largest filers of patents in the country. When I started representing them, they used to say, Ravi, India will take up my application for patent only by 5th, 6th year. By that time, I'll have a US grant, I'll have a European grant. So whatever claims I'll get granted in US and Europe, I'll try to get the similar kind of claims allowed in India, because as a global company, you want more consistency in claims globally because it becomes better in terms of enforceability, licensing, Today, the scenario is my Indian application for patent is picked up first for examination even before picked up by US PTO or EPO. So now the same client tells me, Ravi, how do I slow down my application in India so that I can hear back from US first and then I'll take a call on India. So it's interesting times in that way. Yeah.
Another thing which I've noticed is that among the examiners, the numbers were less. If you took at early 2000, all over India, there were 36 patent exams for all fields of technology. Okay. And then there were lack of speciality. So there were places where a non-pharma background examiner was examining a pharma bag. A mechanical engineer was examining a chemistry patent. This was so common. I think both of us have seen.
Absolutely.
And to explain to that examiner, it was even more tiring and frustrating. At least that has stopped. Now you have proper background and technology domain people, and who are usually in the same page, speak the same language. These are massive developments in India. Can you imagine the number of patents being filed in India in such a large country, having just that 26, 30 patent examiners for all fields of technology? We're close to 1,000 now.
And as we speak, right now they're hiring another 550 as we speak. So they're building the bandwidth. Yeah, things have kind of changed for good. Of course, there are areas, as I said, we can do better. Yeah. Okay. Any other questions? Done?
Thank you.
We are done. Thank you.
Up next, we have Dr. Suryamani Tripathi, who is an international lawyer, registered Indian attorney, and accredited registered technology transfer professional. At present, he is head of legal services at ICRISAT Hyderabad. He also holds a PhD in plant science with CSIR India Fellowship, international masters in biosafety with fellowship of UNIDO and the government of Italy. He is a recipient of an associate fellowship at CISDL Canada and a scroll of honor by the International Council of Jurists. He has a diploma on fostering innovation and commercialization of IPR from the Copenhagen Business School, Denmark, and Certificate on Law of International Organizations by the United Nations Institute for Training and Research. He was instrumental in the establishment and sustainable operations of the Intellectual Property Facilitation Cell and WIPO's Technology Innovation Support Center at ICRISAT. As a techno-legal expert and solicitor, he is also facilitating transfer of technologies, contracts negotiations, and IPR commercializations. He has extensively worked in the field of patents, geographical indications, plant varieties protection, technology commercialization, and has contributed to various national and international forums. So we would like to welcome you on stage now.
Thanks for long introduction. Good afternoon. Thanks, Ananda sir. He's my professor. So whenever I get opportunity to work with him or interact with him, it's my I can say it's my privilege. And he has asked me to give something on that, but practically we face or deal on day-to-day basis. So my background is also a science background. I'm a scientist converted lawyer. So if anything related to science, I can connect with the science and the law. And since I am working for a research organization, on a daily basis, I face the question and queries of the researchers, scientists. Because as a lawyer, we deal that what is written in black and white. And we say this is possible, this is not possible. But from a researcher point of view, scientist point of view, I have put a lot of effort in that. I have done a lot of my work. And you are saying as a lawyer that not possible. This cannot be done. Others are doing that. I cannot transfer, I cannot use. How you can say like that? So this is a very common question on a daily basis we face when we are interacting with the researchers, scientists and innovators. And that type of problem what we face when we interact with the entrepreneurs. So generally I interact with the incubators, the entrepreneurs and that ecosystem. Startups, their founders, their new entrepreneurs, when they come for two things. One set of entrepreneurs, they want to do business. They are not innovator. So what they want a technology which is already available or IP already available. They want to run a business and they want to understand that how they can start business. The second set of entrepreneurs, they are innovator. There are scientists, researchers, students. They innovate something, create something, and with their own invention, they want to go ahead. So for that, they come and ask for advice. So I have been serving all these startups and young entrepreneurs, I can say, from last 15 years, 13 to 15 years. And I have seen that this trend is very common trend. Mainly from the young innovators, when they come, they say that I want to start a business because my friend is doing, my relatives is doing. And the first question I ask that whether you want to be innovator or you want to be an entrepreneur, because both are very different things. Running business is not an easy thing. Running business is a very big challenge. You might have a very good technology, but can you run business based on the technology? If you cannot run, you are good in innovation, be innovator. You license your technology to others, remain innovator, create new innovation, go for a new patent, go for a new innovation, and license your technology to the institute, companies, startup, or other startup, fellow startups. So these are the things, certain queries, questions which are very, very common. If you have any query, you can stop me, you can interrupt me, and you can ask question. I will try my best that whatever learning I have done, I may not be able to answer all your queries, but I will try my best. That's only I can say. So at ICRISAT, we have 3 incubators or incubation support system. The oldest one is the agribusiness incubator, that is agriculture based, where we take care of all agriculture related innovations, entrepreneurship. This was established with the support from the Ministry of Science Technology, Government of India in 2003. And then later we realized that agriculture is progressing towards a digital one. And we started getting a lot of requests, mainly in the area of technical support or some marketing and business support, some consultancy in the area of digital agriculture or high-end technologies which are linked with the digital software, app-based or sensor-based, drone-based, such kind of high-end technologies. Then we established the digital agriculture iHub also, innovation hub, where our the scientific team coming from the digital agriculture team, they are helping the entrepreneurs. We have a co-working space also. You can come and sit also. Agriculture includes various parts. I cannot say that agriculture means only this mechanics, only physics, only chemistry. Agriculture is a subject where you can include everything, even humanities also, economics also. But later we realized that there are certain specific requests for a biotechnology based research because you need specific labs, specific types of technical support and the mentoring also. Then with the support of Department of Biotechnology, BIRAC, we established the biotechnology incubator. So all three kinds of setup we have. As a legal and IP professional, I am serving both, all three, along with my duty to the organization as a legal head. So legal head is my core job. These are my side job. Why these are my side job? Because that's my passion. I am coming from the science background. I want to connect it with the innovation, science, so that I know what is happening around the world. And this is the best way to connect with the science, because innovators are coming and they have a queries, they have an invention. I can upgrade myself because I am a professional. I also have to grow in the challenges posed by the AI. So if AI can put the challenge to my job, I have to upgrade myself. So these are the types of nature, and I interact a lot, not only these institutional ICRISAT-based incubators across the India, various incubators, and we have established many incubators in Africa also. There any query related to IP and legal is coming, that also I am supporting based on my capacity. What we do? So from an incubator point of view, the mentorship, knowledge sharing is the most important aspect, along with the consultancy, along with the support, technical support, lab support, especially in terms of the IP and legal. We will restrict only to IP and legal. We will not go to the incubators, what services they are offering in technical, business, finance, many other areas are there. In IP and legal, the most important role we have to play, we have to train the entrepreneurs, we have to train the incubator staff, because every place, every location I cannot go. I have a limited bandwidth. So what I am doing with my own incubator team members, their managers, officers, I am training them. Along with that, we are conducting IP and legal clinic at a various intervals, at a various organizations. And then we go and ask, we take the queries, answer those queries free of cost. We don't charge anything. It's a free of cost, like this session, this program. It's a free of cost. We ask the queries and give answer to them. It is up to them that whatever, wherever they are going, they are interacting with any attorney, at least they should have a basic idea. Because in the legal profession, especially, I'm not aware that what is around the world, but in India, a lot of misguidance is there. You go and you get a misguidance. So it is our job that we should give a training, basic training to the entrepreneurs, to the innovators, that if somebody is giving a misguiding, that you can file global patent. They can say, no, I heard that there is no concept of global patent. There is a concept of global patent application, but there is no concept of global patent. I think you are wrong. So if you say like that, attorney will feel, oh, this gentleman is a aware, much aware, learned person. We should be honest with the concerned person. So what we are doing, we are conducting a various legal clinic, training programs, hands-on training program also we are doing. Another aspect that we also interact with the policy makers. I can give a very good example. We have been associated with the Telangana government and the central government of India. There is a scheme from the government of India. I will provide details for that, where you can claim the reimbursement of the patent filed by you, because money, IP means money, investment of money, return money. So if there is no money, if you are not earning money, then don't invest money. That is a fundamental rule. Invest money if you are earning money, or any loss. Protection is that for protecting from your loss. If there is no monetary loss, don't go for investment of IP, because IP requires money. National filing, international filing, every stage you have to pay to the government, you have to pay to the attorney, you have to pay to the renewal fee. So what we are doing, we are informing the government agencies that startups, MSMEs, they cannot afford the cost. The government should offer some financial support to them. So there is a scheme from the Ministry of MSME, Government of India, that international patent application, you can claim reimbursement. We face the challenge that getting reimbursement is big challenge because you have to run to office. Then we recommended for online claim submission. Now you are getting Aadhaar based online directly to your bank account. Then we said that government is giving only patent. Why not trademark? Then government approved trademark also. Then we again went back to the why not design? Design is also part of that. Government has approved design also. Now we are pushing for plant variety. Geographical indication also given. So that means geographical indication, trademark, design, patents, international patent, national patent. You can get the claim reimbursement from the government. Whatever the money you are incurring, there is a limit. I will share that. So, both international also, national also. So PCT application also, national also. So our role being a public organization, international organization representing the cause or benefit of the entrepreneur or startup or innovator, it is our role to go and communicate with the government agency, inform them that ground level, these are the challenges, please work on that. Like we have been hearing that the duration of the filing and duration of the grant. I remember when I started doing practice, I used to get trademark application approved 3 years, 2 years, 3 years trademark application. And I used to say that why this is happening. This is a very simple, clear-cut case. Why examiner is taking too much of time, and to buy time, unnecessarily they raise objections. Now the time has changed. Now we are getting 30 days. In 30 days, we are getting confirmation on a trademark. So 3 years to 30 days, it's a big change. Patents, we are getting 6 months. I have a case for 6 months, 7 months for a startup patents, woman entrepreneur patent, woman innovator patents. So this role we are playing, that we are interacting with the government bodies and informing that policy change. We conduct a lot of program, especially on a training. We provide hands-on training. Like for a patent, why every time you need to go to the attorney for a prior art search? You can do your own search. It's like you for buying your product and services, you do Amazon search. In Amazon, you search all various types of products, the profile, lot of things you do. Why you cannot do the patent search on a Google Patents or Patent Lens or WIPO patent sources are there, Indian Patent Office? Only because you don't know. These are the free databases. Don't have to pay any money. USPTO, go and check. European Patent Office database is the best in the world. You can get a translated version. All other jurisdiction translated version in English, and you can do search free of cost. Don't have to pay anything. Only what you require skill to do search. So who will provide? The organization like us, the enablers, the facilitators, the incubators. That is their job to conduct a training program for their incubatees and train them. It's a hardly 1 day, half-day session. That how to do a patent search analysis, at least basics. When you go to the attorney, you are easing their job also, because they don't have to go that level of in-depth search. At least primary work you can do, prepare a good invention, and that's also help you in designing your invention disclosure form. When you are going to the attorney, you know very well that my attorney has to draft a patent application in that particular manner. These information will be required because you are doing your own patent search. You can provide a better information, better format, more information to the attorney. And we are talking about the quality of invention, not the numbers. If your patent is strong, claims are strong, invention is quality invention, then you're having a more value. So all these things we do, we try to give information as much as possible so that you can grow and do your own work. Why only filing patents? There are so many patents granted in US, but not granted in India. That means that patent is enforceable only in US, not in India. You can practice free of cost. Nobody is going to stop you. Only barrier is that you cannot export to US. But you can do, you can make a manufacturing, you can do a product, you can sell in a local market. At least your business will start. And then you will have some money in hand. Then you will decide, okay, because of the invention I earned, I know the value of invention. Now I will create, my team will create an innovation, and then we go for a patent filing. So these are various incentives of using such kind of information and resources. So we apply to the project to the various government agencies and get the grants, because for conducting such kind of activities, you need fund. So being a ACRISAT, being a public organization, surviving on the grants from the various donor agencies, we apply for the grant, and when we get the grant, we offer free courses, free programs to the end users. We also organize technology showcasing also, because technology showcasing is another for a business promotion, not directly related to IP, but when you are going to the market, you need a networking. Like you are here, you might be good in one domain, you are very good in marketing, but you need some finance. So in this room, probably there is a probability that you will get a one person handling into finance looking for a marketing person. That we have seen. I have seen in our incubation program, one person is very good in packaging. They are packaging, doing incubation in packaging, and one person in food products, looking for a packaging. So there is a good marriage between them. One incubating startup is providing services to another startup. That's a very good model. So that's why we go to such kind of program and help you in showcasing your technology, your innovation, your business model. I have a passion about the geographical indication, because I like geographical indication is a community right, not individual right, but very less explored in India. So we provide and support to the various users. I was involved in filing of the Gulbarga Tur Dal geographical indication. I have not ended my connection there. Still, I am connected with them and helping expanding their scope, authorized users, marketing, promotion, wherever possible. And that's why they are growing very fast. So our job is not only to help in getting patent done or IP done. What next? How to go for a licensing, how to go for a negotiation, how to go for a business. Because it's a system, ecosystem. Incubation is an ecosystem. We have also developed a technology database also. This is a public funded technologies. Many IITs, research organizations, universities, they have good technology. You are not aware, I am not aware. Since it is a public funded, they are also not bothered. All technologies are in self. So we have developed a database where if you need, you can contact the research organization or the innovator and get a licensing for that. This was funded by Ministry of Science Technology. So what we offer our expertise, we offer the government support. There are so many schemes from the government you are not aware. IP filing, IP support, the Nidhi scheme also there, that you can get a soft loan, a grant from the government. The government of India, the current government, is giving a lot of boost, lot of incentive to the startups. Possibly we have to go and check and ask, and you can connect with your incubators. The cost-effective service. In the morning we discussed, nothing is free in this world. If it is free, then there is a possibility of misuse. Not always, but there is a possibility of misuse. So for everything you have to pay certain cost, certain money. We also charge certain money depending upon the requirement. So capacity building, training, knowledge, awareness, mentorship free. But if you want a professional service, then we charge. I think already we have discussed that anything related to the IP, whether ideation, R&D business support, invention, lab facility, litigation support, because many times I receive the notice, how to respond. This is irrelevant. Mainly, if you are a startup and if you are doing a very good business, especially in terms of trademark, I have seen, doing a very good business, the big company will send a notice. Without any reason, they will send a notice that this trademark is infringing my trademark. Your patent application should be nullified because it is infringing my patent application. Because they feel threat, and there are various law firms, they are tracking you every day. They track the application, and to build their business, they report to the big companies that this trademark is coming into the market, this patent is going to come into the market, send a notice. So as a small entrepreneur, a small innovator, you fear legal notice, what to do. Then we say, come to us, we will see. Legal notice is not that somebody is going to penalize you. You have to respond to the legal notice. Technology management, commercialization. I have been involved in helping the innovators in technology licensing, especially those who are not willing to do business. If you are going for a technology licensing, especially in biological sciences, material transfer agreement is the most important thing. Nobody is ever about the MTA. NDA, non-disclosure agreement, is very important. You never thought about that. So we advise that you go this NDA, then information, material transfer, because that will show the material is coming from which source, who is the owner, what document will establish the owner, MTA, material transfer agreement. So such kind of guidance we provide to them. We do studies also, especially in terms of GI. We have done 3-4 studies. We have published a paper also. We are whatever we can do, being academics, we can be that also, because it is a mandate of public organization. Whatever work we do should go back to the public. So we should inform that what is happening, what is going on, and these publications will help the policy maker to design their own policy procedure. Because in past you must have seen somebody sitting in the room, Babu, they are sitting in the room and they're formulating a policy, not getting implemented on the ground because of certain challenges. We go and inform them, these are the shortcomings, please work on those shortcomings. Now, this is a very important scheme, those who are looking for a financial support. So from Ministry of MSME, domestic patent up to 1 lakh, you can claim reimbursement. And for international patent up to 5 lakhs. 5 lakhs each application, that means each country application. Trademarks up to 10,000 per application. It's a decent amount. I would not say that it will give a full cost, but significant part of the cost you can recover. And geographical indication 2 lakhs. And industrial design 10,000. All these things are online using Udyog Aadhaar. Very simple process. In 2 hours, 2.5 hours, you can get a Udyog Aadhaar. No need to pay anybody. I have seen so many agencies, they are asking money for generating Udyog Aadhaar. No need to pay anything. You don't have to pay any money, any dollar, any penny to anybody. Everything is online. If your case is an honest case, don't misutilize the facility. If you misutilize the facility, probably government will stop. So if you have a genuine case, good case, you can apply for this and you can get online. This is a very interesting case. When I joined ICRISAT, I joined for a different purpose. I was looking for the biotech regulations and so many other things. I was not looking the incubator function. I was involved in different kind of function. Then one day I got call from the incubator, agribusiness incubator, that one innovator is there and he wants to file a patent. Patent on portable vacuum-based cotton plucking machine device. So there is a manpower. Those who are into agriculture domain, they know that there is a crisis of manpower because of the various government schemes. Field manpower or farm labors getting is very difficult nowadays. So that was the problem in the Maharashtra region, and that concerned person has independently developed a very good device based on a vacuum pump based device and submitted a proposal to the NABARD. NABARD also approved for a manufacturing, establishment of the manufacturing unit and all those things. And then I was called for helping in patenting. As a lawyer, first job, prior art search. I had to do a prior art search. What is happening? And I asked for invention disclosure and did prior art search. Very surprised to see 2 years back, somebody is already exact same invention, everything same. Got patent, Indian patent in Maharashtra region. Then I taken out the patent application and given to the innovator. Say that now you identify what is the difference between your invention and his invention. Then he started blaming me that you have transferred I have given information to you, you have transferred my information to that person and he has filed a patent and he got the patent. I said, listen to see the document. This is a 2 years prior to that. This is already granted. And in India, at that point of time, it's I think 10 years before, 10, 12 years before. In India, getting a patent in few days, impossible. Forget about the days, in years, not possible. I have nothing to do with that. And you can go and check the government record. I am not an attorney. I have no concern about that. I am trying to highlight that your invention is more or less, as per my knowledge, more or less same or similar to that invention. Can you identify what is different? Then I can draft an application and submit your application, or we can go and challenge that. He said, no, exactly same. That means there is a high possibility. In the morning, we discovered the problem. Innovators who discuss to work on the problem. This was the problem. Various innovators were working. One innovator was quite smart, did work, and it was first he filed a provisional and then complete specification, got the patent. In a comfortable position, a person who did good job independently, got the project, funding from NABARD, but cannot do business. Because you have to take a license, then only you can do business. You have all resources only because of one IP. It was a very shocking for me because I was a new professional. It was very shocking for them. It was a very shocking for my incubator. They said, why we have involved you? Involve lawyers, such kind of problem will happen. So why we have involved you? Because of you, now this is a problem. So I said, at least you have involved me at this stage. Think about that. He start doing manufacturing, establish a business, and after that he gets a notice. Think about that point of time, litigation cost, reputation cost, money cost, every will go. At least now it is in safe hand. At least I would advise go and take a license from the person. If you don't want to do business, negotiate and get a license. I'm not sure what happened after that, but this was a very eye-opening for me. That's why we discuss in that FTO is, sir has mentioned, FTO is very important when you're going for a business and if you don't have IP. If you don't have IP and if you are going for a business of any other person IP, preferably go for FTO, feed into operate analysis, if your business involves capital investment. Because you invest a lot of amount of money and then you may not be able to use that. This is another good example that what we do, because we are a research organization. So when an innovator is coming, we always advise that why you are limiting yourself to this part only? Can there be any other variants? So we always help them with the help of the scientist or with the help of our knowledge, that work more on that, generate more data, create more studies, go for a chemical testing, go for a validation, go for more formulations, clinical studies, so that you can have a strong patent application, good patent application. So this fellow was, this person, he was professor in home science college. He was not entrepreneur, he was. So he, during the process of that, he innovated something. The basic problem with the millet is the two aspects. One is the binding. Binding of millet is very difficult when you are trying to make any finished product, cookies or anything. Second is the taste. Millet is little bit bitter in taste. So when you compare anything item with the wheat or rice, you will not find that fine in taste. So what he did, he tried his best, a lot of experiment he did, and rather than using chemical binding agents, he used the fruit pulp and various combination of the fruit pulp in binding this. And then he came for this validation, the life, what is the life cycle of that particular food product, and other chemical validation. Then we interacted, and I identified it looks to be very novel, new. We should go for a patent filing. Then I advised for patent filing. He got the patent. Then he said, I want a trademark filing also. I said, yes, go for a trademark filing. Trademark also filed. Now established his own company, new brand, resigned from the job. He's Hyderabad based innovator. You can go and check. He's in here only. You can go and check. He's pasta, noodles, whatsoever you can say that he is building on a middle-based system. So this is another example that you need a right mentorship, right hand holding at the right stage. so that you can develop your formulation, you can develop your innovation, and then it can be patented. There are so many series of examples like that. Mainly those who are innovator have no business sense, and coming from the university or colleges, the professors also, we have seen, because you work only in your area. You are not collaborating with your neighboring lab. You don't know how the other department, microbiology team or a chemical team, how they are interacting, what kind of experiment they are doing. If you can collaborate, the type of invention, the quality of invention can be very high level, and the quality of patent also will be very high level. So we should focus on the quality, not the quantity. This is another very interesting example, old one, but very close to my heart. These are the three ladies. They have no idea about business, no idea about technology. Just one day, because of some fair exhibition, some fair or something was there, they landed in the campus. And when they interacted, like we are interacting today, they interacted with the fellow entrepreneurs, and they decided that they want to do something. They went back, discussed with their family members. Family members were not very okay, not very happy. They said, from where you will get the investment, from where you will get a technology. This is not, business is not a job of a woman. But anyway, they were, all three were having some interest. They came back. They discussed with me that discussion was not on IP. Discussion was how to formulate a company. How to start a company? Should I go for proprietorship? Should I, somebody is advising to go for LLP? Somebody advised that go for company. So what should be the ideal way to start? And then I said that you don't have anything. Why you want to? Opening company is very easy. Within a week you will open, but closing company is difficult. Think over. First you see the business potential, business prospect. Do some research on that. Anyway, then they say that they want to connect with the research team. If there any formulation, anything is there, we have a food department, food technology department is there. We connected the food technology department. They had certain formulations, product formulation, products were there, but not at the scale of marketing or business, because it's a research organization. Scientists have done job. Then they said they want to do, they will do the market survey, and they will try to refine. They will provide the feedback to the research team, and they will refine and they will develop a product. So we have a pilot plant within our incubator. They use the pilot plant. Using that, they did a test marketing and they started doing that. And so there is no IP in this. IP means there is no patent, because we, as ICRI said, being a public organization, we discourage filing patents. We believe everything should be in public domain. We have only filed 2 patents till date in last 50 years. So in this case, we gave technology to them. Technology transfer doesn't mean that you have to license document and hand over something. Giving a training and that know-how, trade secret, everything, that is also technology transfer. So we given a technology, we gave a training to them. Now they established a very good company. And when they started producing, manufacturing, they were lacking for a business support. From where they getting business? So what happened? We got the project from the Telangana government. Telangana government gave the project that we have to supply Anganwadis, school and various other places millet-based food product. We thought it's a good opportunity. As a research organization, we cannot do business. These are our entrepreneurs. They can do business. They have a manufacturing unit. We have given technology, our technology. We said this is the best. We can do a control. We know the technology, performance. We have given a contract to them and they supplied. So they started earning money also. This is another way of giving incentive support to the entrepreneur. So we provided technology, we provided training, we provided hand holding and the business also. Now they are self-sufficient. They are earning their business, and wherever possible, we are interacting with them. So from incubator side, what should be ready? So when I interact with any other incubator, I say that if I'm an innovator or entrepreneur, if I'm coming to you, certain documents should be ready, certain services should be offered to me. That means if I want to know the company, how to select the company, if I want to know, can I select this trademark, if I want to choose a domain name, these are a basic thing, very, very basic thing. It should be given free of cost. Offer me free of cost. Then there are various formats and templates, like you are going for a contracts. These like in invention disclosure form. For such purposes, why you need various types of forms, downloading one from this place, one from that place? Better that we can ask that already template is there, format is there. You take this and fill and give it to the information. So various types of formats, checklists should be provided to the entrepreneurs, innovator, free of cost. Checklist already I mentioned, and help in negotiation in IP licensing. When you and go individual capacity, you go and negotiate a big company, possibly you will not be able to negotiate in that level because they are a dominant player in the market. And that I have seen. I used to sit with the innovators in technology licensing, because when we represent as an institute and a neutral party. And we are also equivalent. We have an international organization, global presence. So when we represent, we have also kind of matching status. So then you feel comfortable. So incubators, the support enablers, the IPFCs, they should also provide that kind of support to you, that they should not intervene your business proposition, but they should sit with you, that nothing wrong should happen with you. So that kind of support I think should be given to you. Legal drafting, agreements, NDA, MTA, this should be also offered, because if you are doing all kinds of work through one enabler, and then for legal support, where you will go? Do not run here and there for all the kind of thing. And then IP-based business support, whether you want to licensing, because many times I get a query, should I license? Should I assign? Should I do business? Assign means sale, absolute sale. License means I am giving a license to you and to others, and I can pursue my own business. I advise based on your competence. If you are not competent in doing business, don't go into business. I cannot do business, that's why I am in service, but I am a lawyer, I can do a profession. I can do business related to legal services only. But if you say that go for a marketing and promotion, manufacturing, possibly I am not suitable person for that. This is not suitable job. I am lacking the competence in that. For an innovator, forcing innovator to go and do business is not always good. Innovator, this entrepreneur, forcing them to innovate, because your mind is in money earning, not in the innovation, not sitting in lab and doing something work. So why should I force you to innovate, go and innovate something? Innovation is there. Already we have seen that there are so many companies taking a license from IBM, from Sony, from other places, and then doing a manufacturing and doing a market and business. Why you need always to go your own IP, your own innovation? Market available is there. You start a business, take others IP, start business, earn money. Then you think of having a R&D, whether R&D is required or not required. And we build a network. So it's a kind of a network, information. I am here only because of network. Because he is my professor. After my completion, my degree, law degree, still I am in touch with him. And he is honoring me, calling me, inviting me. So that means it's a both sides of relationship. If you build a relationship, if you build a network, possibly you will get more knowledge, more information, more resources. That's enough. If you have any query, you can ask.
Dr. Surya, my name is Rajiv. I see so many people are filing for the similar patents, right? I just want to understand from the common man's perspective how this authority will define which pattern is already existing and which is becoming a copy pattern of the already existing pattern. Now, you spoke about that vacuum cotton picker. I mean, during our session, one person mentioned about already 600 plus patents pending related to the EV line of business. I mean, from the common man's perspective, for me, EV, if it is a bike, all run on the same mechanism except a few features here and there. So how would this, authority will define which pattern is already existing and which is becoming a copycat, and how the pattern would be authorized in the process?
So I will ask your, I will answer your query based on the question. I ask one question, you answer that.
Yeah.
Possibly it will be better.
Okay.
So you see that you have been using Wi-Fi. How long have you been using Wi-Fi?
From past many years.
Many years means how many years?
15 plus years.
15 plus years. You see the 15 years back Wi-Fi system and now Wi-Fi system. Do you see any difference?
There is.
What is the difference?
I mean, in terms of the availability, now the feasibility has become more. The service providers have become more.
No, service, forget about service provider. I'm
Yeah.
talking about a device. Wi-Fi device, functioning of the Wi-Fi device 15 years back and functioning of the Wi-Fi device today. What is the difference?
From the user perspective, the speed has become more.
You can find number of users there.
And then
Device has become more accessible. I mean, compatible security wise also it is more secured in terms
so
of.
these are the features. Because I was analyzing a Wi-Fi device, and then when I started history of the Wi-Fi device, when it was created only for a small room, because the data packet is coming and going, and that's why you talk about speed, connectivity of the data. Then slowly expanded. Now thousands are 10. I would say 10,000 patent on the Wi-Fi device, because every invention is adding to that and significant. Now you see Wi-Fi device is working in field.
True.
When you are traveling, that is also working. Now we are talking about Wi-Fi device in flight. To see same Wi-Fi, but the improvement has gone to next level. That means efficiency of invention has gone. So as an examiner and an attorney, when you are coming and asking me, I'm taking the same example. I have developed something Wi-Fi and I want to file a patent. And I will see all the searches, all the previous patent and non-patent also. For the patentability, only the patent is not required. Non-patent databases also. Books, manuscripts, YouTube, everything I will do a search and identify, okay, these are the problems. No invention, prior invention has given solution to that. This invention is giving a solution to that, and that's why this is patentable invention. Another example, like take mobile battery. Mobile battery, because of long features and other thing, the duration of the battery is only 1 day. I'm creating a battery, same battery with a modification that can work for 2 days, 3 days. Then the quality, efficiency is at a higher level. Then I am eligible for getting a patent. So examiner, attorney, then they will see that what improvement you have done from the previous knowledge, and whether that improvement is a significant improvement or a minor modification. If a minor modification, not eligible for patent. If a significant improvement, then definitely you are eligible for getting patent. Any other query? It's a free of cost session, free consultation. Go outside, lawyers will charge hourly basis. Please use mic.
Hello. I just have one quick question regarding the enforcement of any of these, like GI. Would you also offer support with that? Because particularly with GI, I see enforcement of that and infringement like that will be a problem. So do you support?
We have not come across any request for a GI enforcement, because GI is basically a community right, not an individual right.
Correct.
So nobody has approached us, but we have provided support in the IP enforcement, like a patent enforcement, trademark enforcement. We have received requests and we have provided support.
Yeah.
Till date, nobody has approached us for the GI enforcement. Though their cases are there,
There are multiple cases.
but I will advise that rather than approaching to attorney at this stage, first you write to the geographical indication registry. See that what they are saying that. Then you go for a litigation in another part. Mic here, please. Okay.
Sir, sometime back there was a dispute regarding BT brinjal. Can you please explain this?
BT brinjal. This is not related to IP. This is related to the regulation.
Plant varieties.
Not plant variety. This is related to biotech regulation. BT brinjal is related to the biotech regulation, whether we should allow or not allow. This is not related to the IP part. Just BT is a protected technology of company, seed company. But anyway, biotechnology based GMOs are regulated food product, not allowed to release in India. So if you want to release any GMOs, you need approval from the Department of Biotechnology and Ministry of Environment and Climate Change. So for that purpose, there are various authorities are there. RCGM, GEC authorities are there. You have to seek approval. PT Brinjal, despite having a successful technology, despite having already launched in Bangladesh, possibly we might be getting also PT Brinjal from Bangladesh to India. We are not sure. Already it has been, but because of the regulation part, it was not approved by the government. So that's why it was not released. IP issues were not there in that. But recently there is a case, judgment case, very good case related to plant variety. I think a Pepsi case is there that some farmers from the Gujarat, they infringed this plant variety of the Pepsi and they filed the case, and subsequently plant variety was rights were revoked by the plant variety authority. And now the Delhi High Court has said that this revocation was a wrong thing because this was not based on the correct premises. So plant variety is a very good case. Delhi High Court, I think it's a 10-15 days back case. It's a very good case. How the plant varieties are given, what are the rights given in the plant variety, what are the farmers' rights, what are the patent rights. Good analysis, very good analysis in that case.
CRISAT is also developing new varieties of rice.
We develop variety, but we don't file a release variety because our mandate is to give to the national partners, state agriculture universities and ICR centers. They release the variety. We don't go into the market. Our job is, our mandate is to do research and give back to the national partners, national research organization.
I think there are some research going regarding rice.
We don't work on rice. We have a mandate crop of a groundnut, chickpea, pigeon pea, sorghum, and millet. So rice is not our mandate crop. Rice for an international level is a mandate of IRI, International Rice Research Institute, based in Manila, Philippines. Rice is not, rice, wheat, maize are not our mandate.
Thank you.
Hello, sir. My question is related with GI, not with the IP and startup. Now, who can apply for GI? Because this is a community thing, as you are saying. And sometimes what happens that the folklore, they are not aware of this GI. Therefore, who can apply and how a person can apply?
So I can give you my example that we were working with this Gulbarga Tur Dal. GI should be ideally applied by the community which is owning that GI. The community which is involved in that. So in this particular case, because the farmers are the real owner, so who will apply? So that was the question with us. Then we engage the local research organization, which is the government body. And then we engage the farmer producer organization, FPO, which is representing the farmers community. And all the farmers were the member of that company. And both these organizations submitted a GI application. And they applied and they got the GI. So ideally community which is owning that, but who will combine them? Who will convince them? This is a very tedious job. Who will ask them to form society? It's a research organization, government body, local body, or FPOs they can do, or any trade association.
So what about the cuisine? Say, for example, some cuisine is...
Hyderabad Halim is there. GI?
Yes, sir. For other states, like some cuisine is there and people are not aware of this GI tag, then who should apply for it?
Community, that's who is owning that.
So this cuisine is everywhere.
Correct, but you cannot apply.
Yeah. Therefore,
I cannot apply.
Therefore, what I'm
That's
asking.
it's a GI is there, and I am aware that not registered GI. Merely they are not applying. I cannot go and apply. I am not the custodian. I am not the owner. I am not the community part of the community. You and me cannot apply. We have to go and inform them. You form a group, go and apply. We will help you. That's only we can do. We cannot apply on their behalf.
NGO can be involved in this?
NGO can be involved for hand holding and mentoring, and that's why 2 lakh rupees is for that purpose. Forming group studies, convincing them, documentation, and all those things. GI filing fee is only 5,000, 10,000 rupees. Government fee is only that. 2 lakhs for whole process and work.
The task is to bring them together.
Difficult, most difficult task. Because we are dealing with the community.
Thank you, sir.
Can we close?
So just you said about Gulbarga Turdal. What is the difference between Gulbarga Turdal and other where we found?
It's a very good question. That's why geographical indication means uniqueness because of your geographical location. So Gulbarga Turdal soil has a unique character and texture and lot of physical properties. Or we say the agroclimatic condition of particular soil is very different. Lime is there, some other chemicals are also there. We did a lot of soil testing also. Because of that, the taste of that particular tur dal is very unique. The shelf life is also very high. The sweetness is there. Some aroma and smell is also there. So when you prepare that, the dal cultivated in that particular region, not here, in that region only, and cultivated in any other region, then you can feel that, like basmati rice, when you cook the basmati rice, the size, texture, color, aroma, a lot of things are there. Then you differentiate, these are different things. And that's why this was given only for that. Now I think tandoor also I got, this region, Telangana region, tandoor also, after that, because they thought that why tandoor should not be given, they applied, they also got that tandoor tur dal. But that is because of their agroclimatic condition, atmospheric condition, soil condition, they are getting a unique taste.
Thank you, sir.
Thank you.
Thank you, sir, for that very detailed presentation. Up next, we have Dr. Rahul Kapoor, founder and currently director of Turn IP Innovations, who has over a decade of experience in patent analytics, research, teaching, and consulting multinational firms on intellectual property rights. He obtained his PhD in innovation management from LUT University, Finland, and has over 15 research articles published in reputed international journals. He's also the data architect of IPgram, a global analytics platform covering over 100 million patents, trademarks, and designs. The platform was successfully acquired by a UK firm in 2021. Through Turn IP Innovations, he has impacted over 90,000 scholars across India within the fields of innovation, IPR, entrepreneurship, big data, and cloud computing. Sir, if you would please take the stage.
Thank you for the great introduction. Thank you to DPIIT Chair Professor Dr. Ananda Sharar for inviting me. A real honor to come to NALSAR University of Law. Back in the day when we were students, we knew that, okay, this is like one of the best law colleges in the country, and like real honor to actually come here and give a talk on IP to one of the best universities in India. This is the last session. I didn't want to use too much IP because that's what we've been doing. But I do have, so I'm going to share my own story, my own entrepreneurship journey. And we had a very unique IP related incident. So it's like a real IP case study that I'm going to share with you. And then we'll just open it for questions. I'm sure you don't want me to run you through like a lot of slides. So I'll tell you about Turnip Innovations, my own entrepreneurship journey. Especially I'll talk about IPgram. So it was acquired in 2021. So I'll share the journey of IPgram, how we built it, what were the challenges we faced, the unique IP case study that happened with IPgram, and finally the successful acquisition of the product. So I did my PhD in Finland. I consider myself to be a data scientist. I do have a IP background, but my goal, but my key skills is basically building technology products, is to be able to crunch extraordinarily large amounts of data. So that's what I was doing in my research field. We were crunching global patent data, over 120 million patent documents, and we were generating some research, like what are the new technologies coming up, what are the strategies, of these big companies, and so on. And that's how I got those in publications in international journals. I also worked in consulting for a bit. I consulted some of the world's leading companies in patent analytics, General Electric, Robert Bosch, some other pharmaceutical companies in Europe. So these were our clients who I consulted on how to build patent analytics reports, what data means what, and what are the trends that they could look out for. So in 2018, I came back to India. It was my childhood dream, you can say, to start my own company, become an entrepreneur. So finally, I thought that the time was right. I had enough savings, and I thought I had enough skills to be an entrepreneur. So yeah, I decided, can I have a hand mic? I would prefer to walk, if. So I came back around April 2018. And around July 2018, I founded Turnip Innovation. So basically, I got the company registration done. I used the services of an online service provider, submitted all my documents, and I was surprised. Actually, we had our name rejected 1 or 2 times, and but despite that, in 2 weeks or 3 weeks, I had a private limited company formed, completely online. I didn't have to visit anywhere. So these are also some good things. We talked about how IP has become very fast, but nowadays even starting your own company, if everything goes well, even in 2 weeks, you can get an LLP or a private limited company. But I wouldn't recommend starting a company without having some kind of an idea validation. So this is a mistake I did. I thought that in order for me to do business, I need a company. But I would recommend that you don't make the same mistake. If you are in a job, stay in a job and validate your idea, work on your ideas on the side. Try to get some validation from the actual customer. Okay, because company formation is a lot of commitment. There are annual compliances. Okay, there's an audit process. Obviously, all the balance sheet and accounting has to be done. There are so many different forms that you need to file with the Ministry of Corporate Affairs, Registrar of Companies. So you need one person actually. You cannot do it. The founders usually don't have the knowledge or the know-how. So just like you need lawyers to file IP, you need chartered accountants and company secretaries to do all your work related to GST, TDS, audit, board meetings, all kinds of things. So yeah, so I didn't know I was signing up for that. I formed my company. So this is also a reason why I'm telling you that try to delay forming a company as much as possible. So then I hired my first developer. So it was a college intern from a very good institute. And we started building product. Okay, so I already had the know-how in terms of the database side, the data architecture side. What I needed was somebody to build the front end. And so I started building, and within 1 or 2 months, it was clear to me that a college intern cannot build something of that magnitude. Or at least that person didn't have the skill. But it's quite usual, to get a very good CTO, they need to really work and build like really big applications before being able to build kind of customer facing applications which are secure enough and work. And here we were talking about a proper big data application. Okay, so it needs to crunch a lot of numbers. So then I went to a company, basically a software service provider. I went to that company and said that, hey, would you be able to build my minimum viable product? And yeah, they readily agreed. They said that they will assign a project manager, assign a solutions architect. So all these buzzwords that you have in software development. And I mean, it was fine. I mean, I fell for it, but I don't regret it because they did help me build a minimum viable product. So all the backend was I did myself. So all the queries that were running in the background and all the charts that we were making. So around December of 2018, we had a minimum viable product. And I started asking some people that, hey, what do you think? You can perform patent searches. So patent search was one of the feature. And since we had a comprehensive data set, 100 million plus patents from 100 plus countries, it was a very good patent search tool. And then we also had charts. So you could, with the blink of an eye, you could see what General Electric is up to, or what Tesla is up to, or what Facebook is up to, and so on. But the minimum viable product, as it turned out, wasn't good enough yet to actually fetch us, high ticket size products, because it was a very, very big app. The cloud expenses were more than $1,000 every month. Luckily, Google and all these Azure and all these platforms, they give you very good credits. So if you are building something, make sure to avail the free credits. You can even get it for like a year, sometimes even more than a year, so that you don't have to worry about the cloud expenses. All right. So then once I got the realization that this minimum viable product was not good enough, that's when it hit me that I'm burning money. Already 6 months and we had no revenue. So then December became January, January became March. So about 8 months, 10 months, and still no revenue. And that's when I really understood what I had signed up for. So really, things started to hit me in the face, and I realized that I've invested a lot of money, a lot of my time, and it's not working how I had hoped. So I let go of the software development company. So we have worked for like 5 months or 6 months. And then I hired my own developers. And luckily I found some really good developers. And that's when we started making real progress. Okay, but still the burn was still there. Okay, the product market fit had not happened, like not even close. And around April or May 2020, May 2019, so that's almost a year after we started building. Since I had the idea, that's when I thought that the product has become really good, or good enough so that we can attract some corporate clients, or at least universities who were the low-hanging fruit. So I started approaching universities in India, and it turned out that the market in India was not very mature. Okay, they didn't understand something called patent analytics, or a subscription-based patent search platform. So obviously there are so many free tools out there. So it's very hard to compete when it's just patent search. Okay, you need much more than patent search to be able to compete. So yeah, so one good thing happened at that time is that when we were pitching our products to all these companies, and that by that time I had started visiting universities abroad. So in Finland, in Germany, and in many other countries, we started pitching our products. And one good thing happened was they said that we don't need the platform, but we really like the charts. So why don't you make the report for us? And it turned out that the reports got us like moving. So that was the first revenue I had. So June 2019, exactly almost a year after I started, we got the first revenue basically. And that was a report. And then I found out that consulting reports can be quite expensive. Actually, you can even charge $20,000 for a really good consulting report on technology forecasting and technology landscaping. And that's how many of the patent analytics companies in India, they are surviving. So these are very large ticket size products, large ticket size, services. Very few can get it, but you need something unique. And we had that unique thing. So we had that 100 million plus patent data. So that's how we started working. So, but we know in 2020 what happened, right? So COVID happened. And at that time, around just before COVID, I visited a conference. So I had started visiting conferences to attract clients. And I met actually many people in that conference. So I built a lot of my network from that conference. And so what happened was, so after that, I built a lot of network in that conference. I found out that the traction was not there. I worked very hard. I even like aggressively networked in the conference. You know, like how it goes in conferences. So I really knew how to how to network in a conference. For example, I would always keep one hand free so that I can give out my business cards. Okay, many people don't think about it. They just go through conferences and they're not there for networking because they're probably not come with their own money. So I used to spend my own money. So I wouldn't even like eat sometimes. Sometimes I wouldn't eat lunch because that was the best time to network. And if I had a plate in my hands, I wouldn't be able to. So these were some things. And like always, I had some visiting cards in my pocket. So why should you have visiting cards in your pocket and not in your wallet? Anyone?
Easy to view. No, one hand free.
Exactly. I mean, look, sometimes when you are meeting top management people, they're really, really busy, right? So you have those extra like 5 seconds to impress them. And if in that time, if you're looking for your wallet, okay, searching for your business card, okay, that's a deal breaker. So yeah, so you imagine these kind of things that I did, and this was like, yeah, and one more reason why you shouldn't put your visiting cards in a wallet is because the ink gets smudged. When you sit, there's like you put a lot of pressure on your wallet, and then so it's not important, but just so you just so it's worth knowing. So yeah, so you understand all the things that all the lengths that I went through, and even after going through those lengths, I realized the traction was not there. Most of the leads didn't convert. I mean, I got some clients from that conference, but it was not enough for me to pay $1,000 credit, like a Google Cloud bill. It was not enough for me to pay for the expenses of 2 developers who were working full time, 1 data architect, 1 salesperson. So we had a team of 5, and this was in Mumbai. So I decided that I'm going to move to my hometown, Kolkata, just to save costs. But at that very time, COVID hit. And even in that time, there was a general negative environment. And I thought that, okay, this business is gone. It's like, I had seen like many bad things. So then I thought that, okay, this business is gone. So during COVID time, something very unique happened. I started taking webinars to boost the sales of IPgram basically. So these webinars were basically, I would invite all the academic institutes and I would say that, hey, I'll tell you how to do patent search. I'll tell you how you can do like patent analytics, like in seconds. And I was really surprised. The first webinar I did, I had 2,000 participants. Like, I didn't even know that many people. Like, how did it happen? So it turns out the reason why it happened is because at that time education system was completely shut. So whoever was, providing any kind of learning, the institutes would send them. So I would see that, in the Google form, I could see like real time, like all the time there's some kind of registration coming in. Yeah, okay. So I conducted those sessions. And at the end of the session, there was one more thing that really surprised me. I used to get almost 70, 80 emails from people. Like my inbox would be flooded and all of them would ask just one thing after a webinar. Can anyone guess what that one thing is? Maybe you've also attended webinars. Certificate. Thank you. Thank you. And I replied to all of them because at that point I felt like very free. I mean, I felt that, IPgram was not going anywhere. So might as well enjoy this time. And also COVID had happened. So I replied to everyone. I said that there's no certificate. I mean, what are you even talking about? And obviously that was a learning. Okay, that was a learning that this could be monetized. Okay, so the next webinar, or there were a few more. Okay, I still was at I was still, I'd like to think of myself as someone who like never gives up. Like really, I would have still been working on IPgram had it not been acquired, probably. So that's when what I decided was, why not charge for a webinar? So before that, I'll tell you one more thing happened. So an institute reached out to me, one of those 70 emails that I got. An institute reached out to me and said that they would like me to conduct webinars for 5 days, like 1 hour every day for 5 days. And I said that, okay, fine, I'm going to charge 25,000. And then they told me that actually they cannot pay me anything. So they cannot pay me anything. And but yeah, you can charge maybe 100 rupees if the participants are willing to pay. Okay, so again, at that time I was like very, very free. And I decided to have some help. Okay, I didn't want to come for 5 days. I think it would be boring. No matter what I speak, it will be very boring if I speak 5 days in a row. So I got someone to speak for 4 days, and I would speak only for 1 day. Okay, because I didn't want to work for free also. So why should only I work for free? So, so yeah, and actually that was like a groundbreaking webinar. It so happened that I completed my day, like I did my session, and again, I sent an email to everyone who attended the previous webinar that hey, we had a great first day. Here's the recording, and still there are 4 more days to go. Why don't you join? And it so happened that somebody from AICT got that email, and they forwarded that email to all the education institutions in India. And it so happened that more than 1,000 people attended that webinar, and obviously it was paid. Okay, they paid more than 100 rupees. And yeah, so basically I earned a lot of money for just 1 hour of talking that I did. So that's when I thought that this could be something like can be monetized. And I also felt that I had a niche. IP, startups, innovation, these are niche subjects in India. Okay, and there are very few players. So I was like in very well positioned to exploit that niche. And then we started a bit more seriously. So I already had my development team. Luckily, I didn't fire them at that time. IPgram was also going on to some extent, but I had given hope. And then it so happened that so I met someone in the conference, the same conference where I was not eating, the same conference where I did everything I could to know as many people as possible, to give as many cards as possible. One of them got in touch with me and said that he knows someone from the UK who would like to get a free trial of IPgram. By that time, I was like, yeah, sure. A lot of people get free trial, but nothing happens after that. So I just gave them the free trial credentials. And I didn't even bother to look what they were doing, because we had a lot of statistics. We had a lot of stuff where I could monitor what people are doing on IPgram, what are the queries they are running, what charts they are building, and so on. And I didn't monitor anything. And then that UK guy, after a couple of weeks, he said that, hey, can we have a meeting? And then one thing led to the other. They decided to acquire IPgram. And the whole acquisition process took 8 months. So from that point of time till 8 months, all I did was give them documentation, give them know-how transfer, give them database transfer. And I'm talking about, this is like a small app. Okay, IPgram was like 20,000 or 30,000 lines of code. Okay, it's not that small, but it's quite small. Where if you compare, when a company is acquired, that's why the acquisition of companies can take 3 years, 4 years easily. So 8 months was not that much. So yeah, that's the story of IPgram. So since then, I'm in education system. I am teaching entrepreneurship also as an adjunct faculty. I teach to MBA students. I'm an IP person, so I teach also IP patents, One of our courses got AICT approved just last year. So we got a very big boost from that. Course sales rocketed only for that course. The rest of the courses are also good, but people want AICT. And like in my introduction, those numbers are accurate. 90,000 people we've served. So 1,000 of them were the ones from that same webinar. So since then, more than 89,000 people we've impacted. So yeah, this brings me to the IP case study that happened to us. Okay, so sometime in 2019, when we were building IPgram, I got a letter. I got a letter from a law firm who has an office in South Bombay. So you can imagine some really good law firm. And it was kind of a cease and desist kind of a letter that IPgram is, infringing on their client's trademark. And then also I found out the client's name. Okay, so obviously such a good law firm would be representing some really good client. So they said that IPgram is infringing one of their client's trademark, and that we should cease and desist. That's it. It wasn't very super polite kind of a letter. They sent email, they sent letters to all the registered address, office address, everywhere. And at that, can you guess which was this company who we were supposedly infringing? Instagram. The letter, the company was representing Meta Incorporated in California. So, so that came out to me like a shock because I never thought about it. When I gave the name IPgram, I never thought that Instagram would be, people would think about Instagram because I thought that the audience that I'm serving, they're all technology people, they're all educational people, and it never even occurred in my mind until I got that letter. Okay, too late. So anyways, I panicked. I called some people. I called my CA, like, hey, do you know someone who I can talk to about this? And he gave me a contact of a lawyer. Okay, obviously not KNS Partners. I didn't go there or some other big law firms. I went to some really narrow streets in Mumbai. Had a meeting in a very shady kind of a building. That lawyer charged me 2,500 rupees for a 1-hour consultation. And he told me, his advice was, do nothing. Do nothing. Don't respond. Do nothing. And I was like willing to respond to them, respond to the email and say that, hey, no, we are not infringing, we are not doing any of that. And he told me, do nothing. Because my trademark was pending. If they had to do anything, they can feel free to oppose in the trademark office. So I didn't need to do anything. And because I paid him 2,500, if I didn't pay him that 2,500 rupees, I probably wouldn't have listened to him. I would have done some mistake. I would have responded to them. So I thought, okay, let's listen to him because I paid him money. So, so I didn't, actually, that's what I did. I did nothing. I didn't respond to their letters. I didn't respond to their emails, nothing. They sent one more round of emails. And again, I knew that I didn't have to waste 2,500 rupees more to get to know that I didn't have to do anything. So again, I did nothing. And by that time, I had moved to Kolkata. COVID situation had developed. And then I got hold of a guy in Kolkata who was working in a very good law firm. He was a trademark attorney, very, very strong trademark guy. And he had a private practice of his own. Okay, so I didn't go to that law firm. They were charging me like a huge amount of money. So he had a private practice. So things lawyers do, right? I mean, so anyways, it was a great guy. And he told me, so eventually the opposition came. So they opposed our trademark in the trademark office. And then we had to respond. So finally the trademark office sent us a letter That's when I knew that, okay, now I cannot not do anything. That's the time when we have to respond. So the trademark office sent us a letter that these are the reservations from a certain party who has raised these concerns, and that is why your trademark has been objected. So what do you have to say about it? So that's when I got in touch with the lawyer, with the trademark attorney, and he helped to draft a very nice, compelling response to the objections. And yeah, we submitted the response to the trademark office, and we knew, okay, now maybe 6 months, 1 year later, we have to think about it. So yeah, things. By that time, we thought the trademark attorney had told me, who I believed, that their case did not have any water, because apparently you cannot break a word in trademark. Okay, in a trademark, IP-gram is IP-gram. There's no concept of IP and gram. They are not two concepts. Okay, similarly in Instagram, it's not Insta. They don't own Insta. They don't own gram. Okay, they own Instagram. Okay, so it was such that their case didn't have water. It was just a thing that they have to do. Okay, the lawyers need to get paid, so they have to send out these notices. And but also it gives you an indication how these biggest companies in the world, they protect their trademarks. Yeah, they spend real amount of money. They pay law firms who have South Bombay offices. So imagine how much it means to them. How powerful. They are just searching through the registry. Like every few months, they have an audit process. They are searching through the registry. And I can say they were searching through the registry because I searched other trademarks with gram and I found there were some. So I was like, okay, they are probably also suing them. But yeah, this is how important trademarks are. Trademark is basically the #1 IP. Okay, in terms of value. In terms of value to a firm. Okay, and that's also like, if we have to talk about startups, whether or not you file designs or patents or anything, you actually have to file a trademark. There's no way you can not file a trademark. So trademark, I would recommend using some attorney. Okay, just like attorney that I talked to, use his services or use similar services. Don't go for e-filing of trademarks. That's the worst thing. Okay. And I did that, so that's why I can say that's the worst thing. Okay. Because there's no personalization, they would write some gibberish text, and that would be basically what that gibberish text is going to represent your brand. Okay. Preposterous. So always use the services of a trademark attorney, because not only will they search it for you, they'll also give you an opinion that, okay, this might not fly. And most startup founders who don't know about IP, they make mistakes. They come up with some kind of a trade name which is not going to be allowed. Okay, they don't know even how to name a company. Even naming a company, by the way, when you form a company, when you are going to name the company, get the approval for the name, it should not infringe any trademark. Okay, so even at that time, you have to learn that you cannot just put any names. So yeah, the trademark attorney is going to give you the opinion, search opinion, what are the chances, should you or should you not go for this kind of a name, or maybe you want to change something. So these things. So yeah, the final concluding the story, because that case was still hanging, right? So we had submitted our response. Somewhere after 3-4 months after the response was submitted, my lawyer got a message from their lawyer, like Facebook's lawyer, Meta by that time, or maybe they had not changed their name yet. That we should, if we modify the trademark body, like we make an amendment to the trademark that we don't intend to build a social media or image and video sharing application, they are fine with it. They're going to drop the case. And my lawyer, he consulted me that if you want, we can fight them because their case really has no water. They even cannot say us this much. But then still they are very big people. there's really no need to, pick a fight with them. So he said, let's accept it. Let's make a trademark amendment. So IPgram trademark is registered today. So we have a registered trademark. I own the trademark, but not the product. I own the domain name, but not the product. No, in the transfer agreement, I specifically excluded the trademark of IPgram and the domain name of IPgram because they didn't need it. I discussed this about with them, and for me also, it's not game over yet. I still have it. I intend to build something. Exactly. So I didn't, do all that drills in the conference for nothing. So I still have the IPgram trademark, still have the domain name. So I intend to use it again. So yeah, that's the story. If you have any questions right now, it's a good time. We can take some questions till the end of the session. If you don't have, then I can ask you some questions. Yeah, I have one question actually. I thought since this session was about training for startups and this kind of, so I created one question. Let's see if it comes up. This was about me, but yeah, you heard everything about me. This was the question. So big companies, they have capital, they have manpower, they have knowledge. Why can't they enter new domains? Why do we need startups? Big companies are more agile than you think. They are more agile than you think. That's what I'm saying. A company like Apple, they have the ability to take decisions you cannot imagine. I have met a very large pharmaceutical IP head of a very large, I won't name the company. Maybe it's because it's anecdotal, it may be wrong. They fired an entire entire department because they didn't have a good IP report. Okay, they can move really fast. We think that, okay, only startups can move fast. You don't even know how fast Apple moves. Apple as a company, they can take drastic decisions. Their employees work, even in the job description, they have a mention that they work on Sundays. Okay, so people know what they're signing up for. They work weekends, even like it's very normal in these companies. So they are more agile. I mean, if not, okay, fine, they might be slow. Some companies are obviously different from other companies, but
Logistics advantages. By the time they will invest in that, new product or new thing will come up. So they want immediate apply in the business and then go fast.
that's a good point. Yeah. They want, like, if they want to invest something, they want quick returns. But startup also wants quick returns. No, I want quick return. I mean, I don't want to do something that would take 10 years.
Always wants to buy startups. Always wants to buy startups which are integrated into unicorn. Yeah, they have the needs.
That's actually a bad thing for startups. So, okay, yeah, please.
By the time they release the product, they want people code from paper. They will expect code from paper. So that's why we need startups that will be served in a low cost, low price, with both quality.
Innovation economy.
Yeah. I like certain parts of your response. That's what I will be getting at. But by now, can you at least acknowledge that this is not a simple question?
This is a rather complex
This is not a simple question. Okay, when we see a question, we think we know the answer. So if I can get the perfect answer today, that's my final, like, I'll do a mic drop and
Trading is a trade-off. We always try to get a startup which is already successful.
There
yeah,
are multiple
wonderful response.
There
It's
are multiple reasons for it. One would be, big companies have a mandate and a focused target of functioning. Secondly, it is shareholders' money. Okay, shareholders' money, the way it has to be utilized has to go through board resolutions. So it's not easy to do a startup. Second, most of the big companies have their eye on two things. One is the quarter to quarter result and the stock market. Now, it's not that big companies do not have an appetite for risk. They invest heavily into new products and services. But startup is a different model. So, what big companies do is that they fund startups. Many big companies fund multiple startups in different ways. And with time, when they lead or reach a certain size of maturity, they take it. Like the way your company was acquired, it's again, build versus buy.
Yeah, that was a perfect example of build versus buy. Sir, your answer was perfect. Sir, you said something about focus. That was perfect. And but ma'am, how does your response answer this question? Like, this question is basically why big companies, like also sir mentioned, they want to buy startups. They don't want to do startups. They want to enter, they want to buy startups. And that the reason, yeah, please, to multiply the money.
Maybe they validate about the name or brand, whatever they secure at the time.
Can you please repeat it?
Maybe they worry about the name or fame, whatever they have till that period.
Yes.
They worry about that maybe.
Excellent answer. They can't afford a failure. They can't afford tarnishing of brand name. I told you already about brand names, how this big company wanted to save its brand name. So I'll show you my answer for the slides. Okay, similar to things that you've mentioned. And then I'm going to, conclude the session. No one can excel at everything. This is the reality. There's no big company in the world that owns everything, right? Sure, there are very multi-industry conglomerates. ITC, you know this company ITC? Okay, they have Ashirwad Atta, they have all kinds of FMCG products, but this is what earns them money. They are a 100-year-old company, India Tobacco Limited, back in the day, that was the name. Or Imperial Tobacco Company when the British were here. And in the 1990s, they wanted to remove the word tobacco. It had become a taboo, so they named the company only ITC. And they specifically mentioned it has nothing to do with our previous names. Still today, despite them going into so many sectors, this is their core business. If this goes down, the entire market cap of ITC will crash. Take any other business, Google, 90% search and ads. Okay, 90% is search and ads. They will never let go of this. Coke, we all know, signature product. They might have many things, but this is iconic. Mercedes, do you think Mercedes can enter an FMCG domain? That brand will never resonate, right? And this also, they say, Patanjali made this mistake. The word Patanjali was used for vegetable oil. The word Patanjali was used for toilet soap. It doesn't sit right? So that's a branding blunder. So the answer is they are to some extent. I would say that Tata is retaining the names of the startups they are buying. Tanishq, Big Basket, they are naming them. The other Tata companies, Tata Steel, Tata Motors, and Tata Power, these are the oldest. Only these three are the oldest. They are 100-year-old companies, these companies. So they have built their own brand name for a very, very long time in isolation. So even they took hundreds of years to get a name for themselves. So the response is, the why we need startups is because we need someone to work in the niche. Okay, niche is a beautiful word for startups. Niche is a place where big companies will not touch you because they have their brand names to manage. Okay, Okay, they say niche, riches are in the niches. Okay, so even if you go, any online influencer, they will say, try to find a niche, try to find a niche. Okay, and the niche lies in the mind of the customer. Okay, so that's where you can find new ideas. You can develop and grow a startup without intervention of big companies, and eventually either get acquired or make it big yourself. So thank you. Any questions if you have?
Sorry to interrupt you. I have a question that you said your brand name has been rejected for 2 times. Your brand name has been rejected for 2 times, right? And is there any inner meaning of to say the turn IP, turnip? I feel it as turn IP, not turnip. But you are pronouncing as turnip. So is there any inner meaning to that?
The rejected name was not Turn IP. Obviously, it exists, so it's not rejected.
Okay.
Earlier, I had put a different name. It was matching a name of a very big company.
Okay.
But I said turnip. It was originally meant to turn around your IP, so we wanted to be like.
So it's turn IP.
It's Turn IP, yeah.
Okay. Thank you.
Customers would say, I'll accept that name. I don't.
No, may not be related to your content, but I think name always resembles something what is there in your mind. So I'm just asking.
Yeah, and we got a trademark for this. It's registered, and it's a kind of a dictionary word for which we've got a trademark. So it's hopefully we can make it quite powerful. So
Thank you, sir.
all right, thank you everyone. Have a great evening.
Now I invite Professor Sarkar to give out mementos to the main speakers. Dr. Tripathi. And Dr. Kapoor.
Previous when I kept him in the background, all Mudras are asking. All Mudras are thinking, everybody is asking, what is behind?
Good evening. I think all of us had a great time. I enjoyed every bit and every second of today. So I want to thank all of you for coming in to a distant location, almost out of Hyderabad, and spending your Saturday here. I thank our chief guest, Dipanita Chattopadhyay, for finding time and, in spite of our busy schedule, listening to my request and coming. I thank our registrar for finding some time for this event. All my resource persons and speakers who have done an amazing job and kept the tempo high all the time. Thanks to the students and the volunteers who helped in running and making this event smooth. Thanks to NALSAR. And this program was brought to you, like we say, the sponsors. This program is brought to you by the DPIIT IPR chair of NALSAR and NC Banerjee Center of IPR Studies. I'm sure we'll be meeting more frequently in the future, whether physically or digitally. Okay, so stay tuned. Okay, now with that we'll end today's program. I know you have a long journey back to the city, so please have some tea, coffee, and snacks before you leave. Thank you. Have a wonderful evening.